Co-assistant. Alright. Yes. The Lordship kindly gave permit to mention item number 72 of today's list. It was, my lord, fixed at the expense of Mr. Kishore Datta, my lord. I have served notice, my lord, it's appeal, my lord. Fixed matter at 2 p.m. it was appearing as fixed matter. 72. Item 72. You have to wait, Mr. Sen. If it is not, on why urgency is this, my lord. Since 2006, my lord, the reference was made. Then 2019 award was passed. Mr. Sen, in the meantime, my lord, we cannot upgrade at this stage. We cannot upgrade. It is already in the supplementary list. We shall make an endeavor to take it. Since it was, my lord, appearing as fixed matter, that is why I explained. Fixed matter? At 2 p.m. it was appearing. On last occasions, you give us this week if we can reach. Yes, next. Take the mic, madam.
May I have your kind leave to mention your content application regarding your lordship's judges?
This bench.
No, my lord.
That bench seats you mentioned.
My lord, it is very urgent. Tomorrow, the review application and content application is fixed. It is in terms of your lordship judgment in MAT 638/2021. Content application. Your lordship passed direction that all the 14,052 candidates should be included. All those who were interviewed successfully.
In connection with that.
Yes, my lord.
Fresh contempt. Fresh contempt.
Yes, my lord.
It was never heard by us.
No, my lord.
You know it to do.
Kindly fix it for tomorrow 2
Let us see. Let us see. Hand over the slip. Let us see. Yes. Any further mentioning?
Permitted to mention, my lord, for
Grateful, my
inclusion, my lord, of application for stay, my lord. It was returnable on the 17th of February.
But hand over. Yes.
Lordship, this is a habeas corpus matter, Lordship. The lady who has gone missing, Lordship, she belongs to a she is a family member of a legal fraternity, Lordship. This matter was earlier heard, Lordship. I've served notice to the state, Lordship. I'm praying for your Lordship's inclusion in the list, Lordship. Grateful, my Lord.
My lord, if I may be permitted to mention a matter, it is an order passed on 4th September 2024. It was dismissed for default. I have filed the restoration application on within the limitation period. If you kindly include it in the list.
Give a notice to your other side and mention. Yes. Next, anyone the mention?
Petition in connection with the mandamus. Petition in connection with the mandamus of people.
Fresh matter.
Yes.
Yes. Yes, call this.
My lord, may I permit to mention one matter for upgradation. Matter is listed today's list on 69 item. Urgency is the my lord, the father of the petitioner slash respondent died in 1997. Till from that day, several order passed in favor of the petition.
It is not urgent. It was taken up.
My
You have
lord,
to wait for your turn.
petitioner face severe financial difficulties, my lord. That is why.
All right.
And the age of superannuation also is in near, my lord.
Yes. Yes. Call the list.
Yeah, lordship for inclusion.
Matter.
Yes, your lordship.
Fresh matter.
Yes, your lordship. I have served a notice.
Assigned to which bench?
My lord, Honorable Justice is a
Good, sir. Has it been assigned to this bench?
Yes, my lord.
They can now slip down here now. Yes.
What happened?
Item 1.
Already in item number 1.
Yes.
My lord, just a bird's eye view with a small prayer.
Who are you?
My lord, I am representing
The board start.
the 32,000 primary
Sir, why you are
teachers.
so impatient? To be mentioned matter is appearing as if we have to hear it just now and dispose it of. So be patient, sir.
My lord,
Yesterday also at the time of mentioning you insisted like this.
my lord, we are the candidates who are serving for last 8 years and plus number of
No,
months.
no, you are appearing for whom?
For the candidates who are the appellants,
who are serving following a recruitment process from 2017.
Who are they?
They are the primary teachers appointed in 2017 February. And
In item number 1, it is the board is the
well, that's correct, but there are item 1 to 44. May I need not see any of the documents for today. Agree. Well, what happened? No document is necessary for today. Well, just a bird's eye view. Well, there was a there was a recruitment process in 2016. Then we are recruited in 17. We were serving. 2022 writ petition was filed. Learned single bench cancelled 32,000 primary teacher service. Direction of the learned single bench was twofold. One, cancellation of 32,000. Number two, there should be a fresh selection. And during 4 months, we should be getting the amount similar to the para teachers. Now, we were not parties. The board preferred an appeal. The Honorable Division Bench stayed the portion of holding a fresh selection.
You were not parties to the writ petition?
No, we are not parties to the writ petition.
How many writ petitions?
There are all. But I am coming because thereafter the matter went before the Honorable Supreme Court. The Honorable Supreme Court, my lord, also set aside the order of the learned single bench, and ultimately this is lordship, this contains the real bird's eye view. Can you have a look at this? The one of the primary considerations was page 8, that we are not there, we are not even heard. Kindly come to my lord, page 8. Having heard learned counsels from that part. Page number 8, second paragraph. Now we filed an appeal following this order, and then
those persons are working.
yes, we are working because after this order, my lord, now we are working.
Now, who were the writ petitioners?
Writ petitions are Mr.
All were the unsuccessful candidates.
But the writ
2000, all were the unsuccessful candidates.
No,
Selection was done.
Or petition, my lord.
you are.
My lord, what happened in this matter? Petition was filed.
Now, you tell us that who would be the arguing on behalf of all?
But there are 4. Mr. Mojumdar will be arguing, my lord, and if anything is left, we will supplement.
But
there are some points, my lord.
my lord, since we are the applicants,
we would suggest that if you people can sit
We are
together and
My lord, what happened, my lord? There are 2 sets of petitioner now.
Hmm.
For one set, I am appearing. For other sets, Mr. Mojumdar is appearing.
so we would request if you can sit together and decide amongst yourself and so that it becomes easier, no?
Yes, we can. That can be done.
Instead of hearing everybody
That will be done. That will be done. That will be
But
done.
Any addition alteration, you would be there. There will
Will say
be no
fine.
problem.
I have a different prayer. Learned single bench has heavily relied on a booklet in a spiral binding, and that is spread over in the entire judgment. We don't have that
Part
copy.
of the-
Neither we have the pleadings of the board. Now, my lord, in the present environment, we really do not want to depend on any of the authorities because it's our service. We have to survive by our own way.
So you people have been added as
No, no,
We
not
are
added,
the-
can you say?
we are-
Yes, yes, yes.
We have
Can I just-
we have our
can I-
independent
can-
appeals.
Can for 1 minute, Lord. It is the order of the learned single judge. We prefer the appeal before a lordship's court, asking for leave to appeal. Leave to appeal was granted, and there was an initial and interim order. Only
that we understand,
yes, only stay of the termination of service for
but
that-
not the selection.
that went up. Therefore, we are all, Malad, the order of the Supreme Court is very clear. The affected parties should be heard. That affected parties means we are the affected
Mr.
parties.
Valley, the affected parties are all parties in the leave to appeal application. They have
Leave
been
to
all
appeal,
added.
special leave to appeal.
Yes.
Item number 26
All
is
pre-
mine.
Oh,
My leave to appeal.
all we have preferred the appeal. All we have preferred the special
So
leave.
no, all have been allowed to. Their leave has been granted.
Yes,
Leave
yes,
has been
we are the
granted,
appellants.
matter has been sent back to the lordship's court
Right.
for hearing of the appeal.
Very good. So there's
Lord, I am appearing for item number 12.
very good. Then
Your lordship fix, but today there is no so many arguments. If your lordship fix up any dates, we will come and we will argue.
No, that is fine, but I say that to have
you are
that,
similarly situated.
but
with-
I don't have that documents.
No, Malad,
I don't have that documents.
But-
Just, do you have a copy of this paper book? Because the spiral binding,
Yes,
all
yes.
decisions.
Yes,
Malad,
that
what has
paper
happened,
book
we
may
have
be
done-
circulated.
Malad, what we have
All of
done-
us,
Do you have
What
a
we
copy?
have
So
done
I don't
earlier,
have-
we
I
have
don't
done,
have.
no, we have done earlier. Mr. Sakoshan, as in terms of the directions of the other appeal court, Mr. Sakoshan has prepared a compilation so that to advantage to everyone, that compilation, all documents, pleading is not there, but the documents which are essential for the determinations of this case, that compilation is there.
including that
That spiral,
spiral
because-
binding document which
Madam, that is possibly not
No.
there.
This paper book has all the spiral binding documents. That's what I'm saying.
Spiral bonding document, that
Item 1 in today's list
Yes.
has those spiral bound documents as part of the paper book, volume 1.
yes.
Yeah, but I was praying item 1, whatever is the documents, if that is circulated amongst ourselves, we can go by
I'm
that.
saying, so if you can,
Because otherwise, Malad, you will be completely handicapped.
Appeal of the court.
he already has said that you take it from the appellate. This is the later Malad, he has made an endorsement to that effect.
But I have an argument.
Yes.
I have an argument. Very less similar. I have an there. Everybody has his own view and he will speak. My argument is this: if a document has been relied upon without disclosing anybody, that document, on that score alone, the judgment has to be
no, that
successful.
is separate, Mr. Bandyopadhyay. When we are hearing it, Mr. Who is for the board?
But I appeal for the, I appeal.
Mr. Doctor, the paper book can be circulated amongst them so that they can get a copy. And so that no such objection arises at a future.
The problem is this board's paper book. The problem. I am just kind of saying. This is the problem arose when the matter appeal court had taken up the matter. Board has argued first. Then I had to argue in the board paper book or the board paper. All papers were not there. All papers were not
It
there.
is in which paper book?
My lord,
This which paper book contains all the documents?
now therefore a compilation has been made by
That is without that
Without
spiral
this-
binding.
That is
documents.
without the spiral
Malad, in that case, Malad, in that case, probably,
that doesn't contain the spiral bind.
no, Malad, in that case, number 1 could be the spiral binding.
Let us go one by one.
Malad,
This compilation which you have prepared,
Yes.
you share it with
I have
us.
shared.
I have already shared. I have already shared. Does not have the convenience. That convenience brief I have shared. Spiral binding করা একটা 121 পাতার একটা spiral binding আছে যেটা record
Malad, we specifically need 2 things. One is the spiral binding and another is what the boards and everyone said before the learned single bench because we were not
Mr.
there.
Bandyopadhyay is similarly situated with you.
I don't mind, but Lordship kindly
Mr. Bandyopadhyay says there is no such problem. He can start his
No,
argument.
Malad, today I have an apprehension. But that's Mr. Bandyopadhyay's view, which maybe I do respect that. But I feel today's environment is completely different. We do not know, this matter might go before the Honorable Supreme Court. Well, we have had the examples. So now we need to see every document so that we can defend.
This is not the judgment, sir.
Well, I said only two things.
Doctor, why don't you share your paper?
May I make this suggestion? May I make this suggestion? I have the soft copy of the paper book myself.
Very good.
My junior also has. Whoever requires may write to my learned junior. He'll send them by email. Let them provide the email IDs.
Then, well, that is, but that
Press of a button, everything will go. This is one set of documents. The other set of document is which has been prepared by Mr. Shakoshen's junior.
Yes.
Let that also be circulated in the similar manner.
yes,
You have that copy?
No, I don't have.
I have
Correct.
Acha.
The third is the so-called spiral.
Right.
Somebody has to take responsibility for that. Let that also be circulated in the same
Part
manner.
of the paper book.
That spiral binding.
Yes.
Part of the paper book, madam.
So that is a part of the
Very
paper.
good. Then it's all right.
So that can be transferred to them.
Yes.
If the paper book is given, then
Everything will.
So he will give the soft copy, Mr.
That's right,
Mandota.
that's right.
Yes, my lord. Once it is scanned,
We are very sure
it can be
that-
circulated.
So, Mr. Sen and Mr. Lahiri, the convenience volumes that you have prepared, does it contain anything in addition to the paper books?
No,
Then why do you want us to rely on the convenience volume?
I have prepared,
Madam, no point increasing papers.
Yes.
That is necessary for our contention because our contention was never there before the writ court, single bench. We were not parties.
Correct.
So
That's what I asked. Is there any document in addition to this in your convenience volume?
Yes, there will be.
Madam, may I just
But we don't know what is
one thing. Two things are very important.
basic documents, sir.
Two things are very important. Point is, since we are not there, we are having our substantive pleading that we have pleaded in our stay application, because this is the first time we have got it. Stay petition, we have made our pleading. That pleading has to be taken into consideration apart from compilation and other things.
No, that is there now, Mr. Mandota. That is already there.
It is already on record.
As we have requested, you people will share those soft
Yes.
copies.
Yes.
I am fixing up a date on which you start the argument.
Yes, yes.
With deepest respect, my lord, in the compilation which was permitted by Mr.
We would request another thing, if you can make a short, the appearing councils and the group of the matters, so that we will hear the lead council and finish it.
Well, this is not a question of lead counsel, it is a question of everyone has its own view to argue.
We are not saying that. We know that, Mr. Mandota. If anybody wants to add anything, he will add.
There could be hardly there would be no, that may not be required. There may be hardly 7 to 8 councils who would be arguing, spread over to 32,000 number of teachers who have been serving for last 8 years.
Then what is your difference with Mr. Bandobadhyay's client?
My lord, fundamental point like locus, no difference. Now, Mr. Bandobadhyay thinks
Not locus or merits also.
almost like
on mouth thing, don't please
You are
don't put it
similar.
on my mouth, please.
my lord, I do not know.
No, what I think
I
I
do not
don't
know.
think you don't put it in my mouth.
I do not know.
You were there when I argued the matter, practically stay petition, I argued the matter. You know what I know, why you don't know. Now why you are in a conflict? If you do not know, then don't say. Then don't say.
Of course.
Otherwise,
But whether Millard kind, excuse me, Millard, whether Millard, I have argued the matter before the appeal court. That Mr. Gupta and myself argued the matter.
But now we will start
Mr.
at
Dhar, Mr. Dhar, let
Please,
him
Dhar, please. Otherwise, you speak a one. You become Mr. Dhar will become a leading counselor. You both see in the Mr. Gupta argued and thereafter mainly I argued and Mr. Kaur argued. Some portions were argued. In the Supreme Court, I argued. Therefore, Millard, I need time. Whether who will argue which point, what point, I will cover the entire matter, Millard. I need 2 hours time to argue. That whenever you will losses give it, I do not mind. First, last, middle, wherever you will losses will place, I have no objection. But I am making myself clear. Whatever the arguments are being made by the any council, I will make my argument A to Z.
So Mr. Gupta,
Yes.
then you start what you can say. You can start today also. We can get an overview so that we can.
Fix a date, Milord, so that
we can start argument. I am ready to argue even. Or next
It's a long pending matter, my lord.
You are appearing for whom?
On which order?
we also have a copy of the plan.
Which applications have come?
Applications after that order have not been passed, have not been considered. So now if it is understood that those applications not be presently considered.
This order is there. It cannot be, it will not be considered.
Then they will not have those applications.
For the full invitation.
While they are
Into paragraph 90. We make it clear that
But
no
they
petition.
will be, we cannot, let us not make it complex. If anybody comes with a pleading, that will be similar to the pleadings which are already.
No. There is a
Paragraph.
Court is here, if anything.
Just can I read one sentence of the order which was passed by the division bench last order? Paragraph 90 of the order. 4th September 2024. 23. We make it clear that no further pleadings or disclosures of documents shall be allowed any further. Why this order was passed? This order was passed when the matter was being taken up. One after another application was coming. The court has to allow. Court has to say. At one time, court has to put has to stop it. Court has said so many applications are there. If your loss is fine in the year, in this appeal, if the appeals are 30.
Just one more.
In that case, your lawsuit will find 300 or 400 applications are there. Now, if kindly decide first whether lawsuits will go into the appeal or not. If the appeal is hard, everything will be decided. If the application is hard, then applications will go.
We will hear the appeal. Yes, hear the appeal.
Appeal. Therefore, kindly fix up any other date.
The Lordship may simply ignore the applications and continue hearing the
We
appeal.
will start hearing the appeal.
Yes.
Whatever applications are there, there will be counsels for that. We will consider their prayer. Unless otherwise it gets bogged down, we cannot proceed further. So let it start, Mr. Bennett. Let it start. That we will consider. We will consider.
Item 37, there is an application for addition of party in item 37. So lawsuit will consider it now or?
Let the appeal hearing start. Whatever applications are there, we will consider their submissions also, whichever order Mr. Bandyopadhyay is pointing out.
That is,
Going to it, and we will consider.
that is for addition of party, that's a proper punishment.
Then we are fixing it on 7th at 2 p.m. Mr. Shami Ahmed, it will not end on one day. Let it start.
After vacation, let it start. It will start after vacation. This will not be finished before vacation. Your lawsuits have seen that the other matters which I was arguing, your lawsuits have seen your lawsuits have gone to the court after 7 years.
Mr. Bandyopadhyay, we have to start.
I don't mind.
Let us start. Let us see how much time they take. And if it spills over the vacation, that is another issue.
But on 7th, Milord, your Lordship keeps it at 2 o'clock. but with this understanding that the board will start on 7th.
We'll start on that.
Okay. I am.
Yes.
Brother, after board your losses, give me chance. I will ask. After board your losses, give me chance. After board submission.
Yes.
If your losses give me chance, I will argue.
Yes, you argue. Let them finish it off. As you had been the lead counsel, you argue, then we will hear others if so.
Would your lordship indicate regarding these 3 documents which are
We
required?
shall not indicate, this is understood.
Understood.
We should not add words to what has been given, that will create further complication. It is a matter of such a wide ambit, whatever we say, that
I
will
understand.
be interpreted in some other. So it is understood, you please exchange your soft copies. You exchange your soft copies so that we can commence hearing on 7th.
একটা আইপ্যাডটা কিনেছিলাম কিসের জন্য? এই যে আইপ্যাডটা, একটা আইপ্যাড
You are the successful candidate who is working.
We are all the successful candidates. He's unsuccessful.
We are successful. We are successful. Corruption it become unsuccessful.
No corruption, no.
Nothing.
Don't say about corruption.
I want to corruption. Don't show corruption.
No allegation of corruption.
These council for unsuccessful candidates. Only one target. Only yes, he will go. Worldly so speak. He will not kindly see. His endeavor is nothing. I am unsuccessful candidate. Therefore, terminate everyone's service. That is his target. Since I have not become unsuccessful, what is the fear? What is the why? Since I have become unsuccessful, therefore everybody is terminated. And when staying in the court, everybody's service should be terminated. Here they are asking, they are coming for the client. What can you see?
After expiry of marriage.
Let us start.
Cross objections would be there.
Yes.
We should be mature enough.
There is no problem. There is no. There is no. There is no. There is no process. There is no process.
5 years.
Give appointment to us.
We will not end us to anything.
2017 selection process.
Madam, we will argue. Madam, we will show to your lordships. We will show to your lordships how there can be a judicial indiscipline because poor judgments in respect of this matter have been ignored by the learned single judge. And if your lordship says, why Mr. Samim alone, even the learned single judge who has passed the judgment is
against.
No, I am saying the learned single judge who has delivered the judgment now openly is saying, I will see how the 32,000.
But simply bringing up the hits.
I have not brought it. The great council has come here, he has said corruption. That's the reason he is there. No, your lordship do not allow to bring the heat by them. If they bring heat, I have to react. He has said this is because of corruption.
You are accustomed with this heat, Mr. Accustomed.
Which one?
You are accustomed with this heat.
I am also accustomed with this.
Temperatures,
I am also
temperatures,
accustomed.
Mr. Banerjee.
Yes, one side.
Temperatures
it is not
are,
one side.
Mr.
I am
Banerjee.
also accustomed how the councils are attacked me. I am also accustomed. The point is this is a listen, my lord. No, I am not.
Temperatures are soaring to 40. Let's not raise it further.
No.
Temperatures are soaring to 40.
You see,
it's very hot outside.
Why is it
Mr. Banerjee?
No, kindly see. For making a reel,
Even the AC is not working.
For making a reel and send it to the outside and minting money on the basis of the reel by the council, that is not helpful. That is not helpful.
Let us think of the meeting.
Corruption.
Let us think of the meeting.
This will start from 10:30.
Corruption.
So let us not comment on that. Why you are shouting like this, sir? Why you are shouting?
If there was a panel, the thing would have been
Let us start on 7th. Let us start. We will get your hearing.
Then circulate the convenience brief.
Software board
Convenience. If any order is required, but I will.
I am one of the appellants. I have accepted service. Now, my case is squarely different. Mr. Bhattacharya, let us start. On 7th, they will be arguing, and when Mr. Bandyopadhyay, Mr. Bhattacharya, and Mr. Mojumdar, whoever asks, starts arguing. Yes, thank you.
Give love to losses.
Yes, yes.
WhatsApp.
I am meeting with your losses after few time.
WhatsApp. Ratul and WhatsApp, sir.
I am appearing after few minutes, after few hours again.
That's you are ready for that.
I am also ready.
Yes.
Mala, in item 37, this matter, Mala. Item 37, there is a two application for additional party. That will be considered.
The addition of party, let them start. Let us ascertain we will get. আচ্ছা তুমি না এই যে যতগুলি অ্যাপ্লিকেশনস আছে
Seven. I'm appealing the witness with my instructions to not press the. We are appealing for the enforcement directive. Section 0. Lower to the bail. Lower to the bail.
কষ্ট হলে ওই অর্ডার ইনক্লুড এই কখন তো তোমাদের যে কি করবে
There was a direction to file opposition by the enforcement directorate.
This is a habeas corpus matter. What happened? The matter was who was missing?
No one was missing, Mother. There was a point of illegal arrest. I'm sorry, point of illegal arrest because the petitioner here in Malad was arrested from Bombay. He was not produced before that local magistrate and directly was remanded to brought to Calcutta and remanded before the learned session, the special judge for the ED matters in Bichar Bhavan. So that was one of our prime points, Malad. But on the contrary, Malad, there are other provisions of law also which we have.
Then what happened?
He's in custody. He's in custody since November 2024. Thereafter, ED submitted prosecution complaint. Thereafter, we filed this habeas corpus taking up this particular point of illegal arrest. But
Yes.
Now our instructions, Malad, is to not press this because we have instructions to file regular bail applications. Otherwise,
On the prayer of the learned advocate, you are on record.
I'm the advocate on record.
On the prayer of the learned Let the affidavit in opposition filed by
And I have facing one difficulty. But item number 46, I have been engaged as Union of India when I was empaneled as Group 2. And now I am engaged as Group 1. So until or unless it is, I have been engaged as a Group 1, it can't be possible to appear to that. When I was engaged at that point in time,
so what difference does it make? You group 1, group 2 is we are not concerned. You are the advocate. You are the advocate representing the Union of India.
certainly I shall lose everything.
Pardon?
Certainly I shall lose everything if I engage at Group 2. When I was engaged in this matter, I was in Group 2.
Very good. How does that matter? You are still appearing for the respondents.
So until or unless they engage me as a Group 1, how can I appear?
Why? You can appear as a counsel.
I have appeared as a Group 2.
Group 2 is a division made by your appointing authority. Group 1 advocate, Group 2 advocate, Group 3 advocate. We are not concerned with that, but you are representing them. When you are representing them, you argue. What is the problem?
That panel, Group 2 panel has already been expired.
So you are now in the panel of Union of India.
Union of India, but Group 1.
Very good. You sort it out with your engaged. You sort it out and you make argument. You appear and make argument. Yes, what is the matter about?
This is a matter concerning the BSF. I'm not as pursuant to your worship order.
Serve what? They are private respondents.
No, it's only the government. And one of them is your lordship's pleasure is that I serve them. So
you have got the copy?
I have already got a copy of the stay appeals.
Yes, that is what is.
No memo of appeal, nothing.
Memo of appeal are here.
The stay appeal I have got.
But dismissed. Just a moment. Yes, now there is no scope for any stay.
But the only thing is that there's no scope for stay.
You file your paper book.
Paper book, I've already annexed the writ petition.
No,
nothing else because there were no affidavits were called for.
Then you file an affidavit to the stay application.
Yes.
This is under section 40, and under section 40, this order of dismissal could not have been passed. This proceeding is under section 40. So if the proceeding is under section 40, the disciplinary authority could not have passed the order.
Why didn't you bring up the appeal earlier? This is a 2015 appeal. Huh? You have mentioned it in 2022.
Before that also there was, it was coming in the list, but then somehow the others.
The present appeal has been preferred, challenging an order dated
This matter, for my learned to begin, I am praying once for indulgence before the lordship. The instruction was come. My junior is suffering from heat fever. My lord, he is not come to court. My lord, at least, my lord, 3 weeks time to giving time for filing opposition in this matter.
Well, there was a direction to file the opposition by my learned friend. That has not been done. My lord, I have a verbal instruction that there are some vacancies. There are some vacancies cook are vacant, lying vacant. No such written instruction.
No, it is not. Right, my lord, there is no such.
We have already given you time to file the opposition.
Yes, my lord. My lord, instruction is came late, and then my lord, my junior is.
So you prepared it, sir. How long you do? Then we cannot dispose of the matter.
My lord, at least 2 weeks, my lord, it should go to the meeting, then my lord come.
That we are not concerned. Who is to vet and what, that is your responsibility.
এটা দিন।
What is the matter about?
Matter relating to the appointment of the cook by the CRPF authority.
Appointment of
Cook. GD cook. General duty cook.
yes.
I have participated in the selection process. I have cleared the written examination. Thereafter, I called for the PST, PET, physical standard test and physical efficiency test. I passed. Thereafter, I appeared before the detailed medical board. Detailed medical board find me 2 grounds for my rejection. I preferred a review. In the review, I have already show last date, earlier date. The procedure as per the guideline they should have to follow, that has not been followed by the authority concerned, and the one of the ground which is already covered by the standard given by them, although that ground has been assigned. Then another ground, I have a medical certificate where it where where it clearly shows that I am not suffering that problem. This is the thing. I am renewing the prayer for one post. Kindly, till the disposal, one post may be kept vacant.
You don't know the status, sir.
Yes, that's right.
And that you made a prayer, we
Yes,
did not
yes.
accept your prayer.
That's right.
Heard Mr. Kundu, learned advocate, appearing for the appellate. Mr. Royal, learned advocate, appearing for all the respondents. Praised for the extension of time to file the affidavit in opposition. Stop as a last chance, comma. Time to file the affidavit in opposition is extended for a period of 2 weeks from date. Reply thereto, if filed within a week thereafter, list the matter for further consideration under
Forty-eight may I Lordship, I am for the petition.
same matter.
No, my lord, it is different selection process, but matter like same. My lord, last
First time
occasion,
it has
your-
come.
no,
First
no,
time.
no, my lord, your lordship directed them to file the
You are appearing where he has left.
On the last
Somebody
occasion,
else
we
was
prayed for time, my lord. So on 17, they have prayed for time.
Alright, come next Monday. Monday, monthly list. Tuesday করে দাও। Next.
May I appear for the appellant, may I take your lordship's indulgence, may the matter be listed on Wednesday, be taken up on Wednesday. Because the examination has already been conducted, my lord. So I understand, my lord, that within 2 days, my lord, they won't be giving any appointment possibly.
What is the matter?
My matter relates to, my lord, the petitioner, my lord, was working as, my lord, the demonstrator orthotics in, my lord, National Institute of Disability, my lord, at Coronado. Now, my lord, there was an advertisement in July 2024, my lord, for filling up, my lord, the post of lecturer. Now, my lord, the appellate, my lord, was in the feeder post, my lord. Now, my lord, in the recruitment rules, my lord, at the time when the appellant was appointed at the feeder post, my lord, was that, my lord, for promotion 5 years, for deputation also 5 years. Would be the eligibility service. Now, my lord, in 2020, my lord, the recruitment, there was an amendment in the recruitment rules, my lord. Now, my petition appellant applied for promotion, my lord. His application was rejected. He came up before the Honorable High Court, my lord. A order was passed by my lord Justice Arindam Mukherjee directing affidavits, my lord, and my lord, there was a direction, my lord, that my lord, the reserves appointment shall abide by the reserves of the petition. The applicant also applied for deputation. Because there were provision for application, making an application for different.
Then what happened in the writ petition?
In the writ petition, we applied. Since our prayer for deputation was rejected, we prefer the writ petition. Now, the trial honorable single judge, heard that since eligibility to service of 8 years has not been completed in terms of the present RR rules, recruitment rules, so the writ petition cannot be considered. Petitioner has applied.
Now there is a promotional process continuing.
No, my lord. Recruitment process has started by 23rd, my lord, because the advertisement said by direct recruitment.
23rd of?
23rd of, my lord, this month, April, my lord.
Recruitment to which post?
Recruitment to the post of, my lord, lecturer orthotics.
So as a deputationist, you can apply in that.
My lord, as a my lord, since I was working in the feeder post, my lord.
You are seeking adjournment for what? To take instruction as well?
Only for taking instruction.
Or a day after tomorrow.
But 48, can it be taken up on 7th, my lord? Instead of Monday, can it be taken out on Tuesday?
Which one?
48, my lord, just to try it. Tuesday.
So, 48 Tuesday করে দিন।
Tuesday করা আছে।
Appear for the respondent's petition.
Item number 50.
This appeal by Coal India, my lord. It is regarding, the basic dispute is regarding seniority and consequential promotion. There are two channels of mining engineers in the service structure of Coal India. Two channels. The first channel is of second-class mining certificate holders. And the other channel is of the first-class mining certificate holders. In 2000, a policy was promulgated. The policy was promulgated. I will first draw my lord's attention to that policy.
Just a moment. You are representing all the writ petitioners.
With their private respondents, they have remained unrepresented. They have chosen not to appear.
There are
private respondents. They are party in this, but they have not appeared in the trial.
They have not. Did you serve them? This application, did you serve upon them?
No, this step we have not served on them.
So you have to serve. Whether they appeared or not, that is different.
That I appreciate, Lord. Kindly give me a week's time. I'll serve it.
This is at the instance of Coal India.
That is Coal. And in fact, we are supporting their all the private respondents.
The writ petitioners are respondent numbers 1 to 31.
1 to 31. 1 to 31. 1 to 31.
Also, Mr. Learned Advocate appearing for the appellants submits that service upon the respondent numbers 32 to 41 is not yet complete. Stop. Mr. Mojumdar, Learned Advocate, enters appearance on behalf of the writ petitioner stroke respondent numbers 1 to 31. ওটা 30 to 41 hours. List the matter for further consideration on 13th May. Stop. The appellants are directed to complete service in the
Just to kindly do you another favor, I will search them through Code India. Through Code India. Otherwise, I will search them where they are posted or not. Code India will search them. Through Code India, I will file.
Yes, you are for Coal India.
For Code India office, not individual. Just. You're thinking. No, I stand corrected. We have served it already.
Where is your affidavit of service?
Affidavit of service like
Then next when is
I represent 1 to 31 except 14 who has expired. It's recorded.
Except 14 he has expired, then he has to take steps now.
He has expired.
Huh?
He has expired. Nobody is to be substituting him. It's a case of seniority in service.
Kindly make it not today. I look to it.
তাহলে রেকর্ড করো না তাহলে এরম লেখো on the prayer of the learned advocate appearing for the
Next Tuesday, will you?
Next Tuesday. Next Tuesday, what? Next Friday.
Another responding matter. Leading by the Mr. Partho Ghosh. Is online matter.
This is a.
I put the Union of India in this matter. But I am questioning the mentality of this, my lord, appeal. If you will kindly see, my lord. There was only direction for filing affidavit. My learned friend has filed, my lord.
Who has filed?
My lord, the writ petitioner has filed this appeal. My lord, well, there is a direction for filing affidavit only by the trial court, my lord.
This appeal has been preferred on refusal of interim order. Only on interim order refusal, this appeal has been preferred. But what happened in this case?
So where did you pray for the interim order?
Yes, I prayed there. In the writ petition, I prayed there. Specific prayer was there to keep some post vacant for the appellant.
You appear in person.
My lord, I'm coming, my lord. I'm coming, my lord.
Not today. Come tomorrow.
My lord, I am the petitioner.
Habeas corpus. First time it has.
I am for the petitioner. I have assisted Mr. Sarkar, Gopal Sarkar. But after filing this application, some development has been taken out, my lord. So, may I file, my lord, supplementary affidavit, my lord. And you will also fix the date, my lord. Service to the other side.
What happened? Recovered?
No.
Recovered, but they are under police police authority, and also she is now at home.
So then what is the problem?
The problem is that police authority taking during the investigation they are forced to taking cognizance in favor of their taking the brother that.
She is not in an illegal detention. She is in a home under the CW.
Illegal detention under police authority.
He must have been.
As a mother, I am not seeing that for what is the position about my daughter, That is the allegation,
Try to understand. Police cannot custody. Police will keep her in a home under the Child Welfare Committee.
Yes, But what happened, some officer taking the advantage, they are taking witnesses, in favor of the that boy, who is in custody, That is allegation, instruction on behalf of my client, as a mother, Your Lordship, kindly fix next week any date, that I can argue this matter on that point.
You have served it upon the state respondent.
No, Kindly liberty, given, to serve,
Mr. Chakraborty, learned advocate appearing for the petitioners, files a supplementary affidavit. Let the same be kept on record. Let the establish the matter for further consideration under the same heading on Wednesday. On 7th, the petitioners are directed to complete service of the supplementary affidavit upon all the respondents in the meantime. Service complete upon all the respondents.
Yes, deep
If
it is my lord, I am for the petitioner.
Petitioner.
I am the petitioner.
Who is for the state? Who is for the respondent?
Respondent last occasions appeared, my lord.
Rana Mukherjee.
I think he appeared last.
Habeas corpus.
Missing girl is the missing as the married daughter of the petitioner, my lord. When she was in the custody of in his husband's house. From there he is missing.
Married daughter of the petitioner.
The petitioner.
What happened? She is residing at her matrimonial house.
Matrimonial house.
Then why you have filed this petition?
Then, my lord, thereafter, from the house of the husband, he is missing. I was diary, several missing diary I was made, my lord. Lastly, my lord,
who is the husband?
My lord.
Who is the husband?
Husband,
have you served upon the?
Yes, yes, I have served. Evidence service in the record, my lord. And she's been tortured by her husband, mental and physical, regularly.
Why the state is not appearing? Rana Mukherjee? Did they file any report?
No. Last occasion, he told that this is zero FIR. The report.
You have prayed for?
Zero FIR was by the Eco Park. He was sent to the.
You prayed for an adjournment. Why did you pray for an adjournment on the earlier occasion?
No, I have not. Adjournment made by the state respondent.
For the petitioner?
No, my lord, I appeared. Anyway, my lord, I have not prayed for time. State respondent prayed for time.
You
and I have filed evidence service also on that day.
So you give a notice to Rana Mukherjee?
Very well, madam.
And come back day after tomorrow.
Day after.
As well as upon the respondent for the private response.
Right.
Your Lordship, Mr. Arun Kumar Maithe is appearing on behalf of NCB. Your Lordship, I'm praying for now today since he is in another courtroom.
On behalf of Mr. Arun Maithe, they prayed for time. Supplementary evidence kept in the record, and I shall hand over one copy of supplementary affidavit. My lord, kindly look into the honorable coordinate bench order. Thereafter, my lord, advisory board passed the order, and for that reason, my lord, supplementary affidavit I filed. So I crossed the hurdle passed by the honorable division bench regarding my lord maintainability. already, that time, Mr. Maiti raised a question that the matter is pending before the advisory board. And thereafter I made representation one after another, and ultimately,
Mr.
advisory board.
Chattopadhyay, learned advocate, appearing for the petitioner. If he is in custody on the basis of the advisory board order, it cannot be said to be a
matter, my lord, I move before your lordship.
you come with
My
the
lord,
records.
that time, my lord, there are so many.
Let us see, let us
My-
come ready on that. Yes.
My lord,
Your item 55. Yes.
55. Mr. Jayanto Kumar Sanal is on behalf of petitioner. He has not come yet, so I'm praying for short time.
Next Tuesday. Yes, next. Petitioner.
But I am for the private respondents.
State.
Alright. Whether state has been served or not, I don't.
State served.
No, my lord. Yes, my lord, state served.
You know who has been engaged. Stated ke engaged message. You have for the private respondent.
Mal, private respondent.
Respondents.
My lord, private respondent number, but I am appearing on behalf of private respondent number 5, 6, 7, 11, 12 and 14.
8 and 9 you are not aware. 8 and 9 service complete.
My lord, two services which returned as refused, my lord.
Refused.
Yes, my lord.
What is the matter about?
Matter is the I have made representation before the SP police Paripur police district, OC Jharkhali coastal and the Panchayat Pradhan Nafarganj Gram Panchayat. My daughter has not seen locally since last 4 months, my lord.
What is her age?
Now
But that is a 12, my lord. She is in custody of us. My lord, she is our in our custody, my lord. But I am the mother of the daughter.
You are the mother of the daughter and you are the father. So there is a matrimonial dispute.
Yes. And the my lord, there is a dispute of my lord in regard to domestic violence. I have already made a complaint.
My lord, kindly
Matrimonial dispute.
see the page number 31, my lord.
My lord, my submission would be, my lord, this script.
So your daughter is with the mother of the with her mother. If you want custody, you have to go and guardianship act, you file an application there. Why you have come for habeas corpus?
My lord. At the time, 7th December 2022, mother left her matrimonial home, leaving her 9-year-old child in my custody. Before filing that domestic violence application, the mother took away the child from her examination without giving any information to me. After that, I have lodged a written complaint before the Bashanti police station at that time, and I have to wait for 2 days to see my daughter, because when I
But that was of 2022.
yes, my lord.
Now we are
After
in
that,
20.
after that, they file an affidavit of assets and liabilities, where she informed that she is reading in Nafarganj Gram Panchayat school, where I have made an RTA application. They informed me that the daughter was taken away on 31st December 2023. I have seen locally my daughter often when I came out for my business or profession purpose. But since last 4 months, I have not seen my daughter in my village area, my lord. I have made representation.
Why she is saying your
Yes.
daughter is with her?
Yes.
But how can I know, my lord? How could I know that the daughter is in safe custody with the mother?
How will you know means? Mother is in custody. Mother has said that she is residing with me.
After that, I have shown that the
So
learned
for
accountant
that,
is saying that.
so today what do you want?
My lord, kindly, my only prayer is to produce the child before your honorable court.
Produce the child for what?
But
She
I'm
is.
not seeing my daughter, my lord.
If you have not seen your daughter, you have to take other steps.
But no court has not passed any absolute order, my lord, for the custody of the mother.
Are mother is the natural guardian. She will be. You have a daughter who is a minor. Anyway, who is for the police? Who is for the state? You are for the state.
And for the respondent number 9.
Uh-huh.
9.
Respondent number 9.
With him. You are respondent number 9. Okay, say or okay. Oh, mother and wife.
Papi Mondo. Initially, while the petitioner took a loan from me for 50,000. I asked for the money returned back. Then I have been falsely implicated.
That is because you are having a relationship with his wife.
Pilot, kindly see the nature of allegation. So many persons are
Now,
involved.
where is the child now?
Malad,
We are not at all.
You are the mother, you are respondent number?
respondent number Malad 5.
Where are
Happy
you
morning.
residing? Where are you residing?
With me. That is,
Where are
the
you
child is-
residing?
Malad, I am residing in my parental house. Malad, matrimonial dispute is going on in between Malad, the husband, who has filed this petition.
You have filed any matrimonial suit?
Malad.
Huh?
No.
Matrimonial suit file also.
No, my lord. My lord, they have threatened me to withdraw the case, my lord. I have also informed the OC and SC, my lord. The respondent number 7 and 9, my lord.
Have you served this upon the state? Petition you have served?
Yes, my lord. Yes, my lord. I have served the petition, my lord, and filed the affidavit of service here, my lord. My lord, my lord.
I am not at all connected with the incident.
My wife residing in a stone pelting distance, my lord. I have not seen my daughter last 4 months.
There is a approach to the civil court.
You are both residing under the same police station?
Yes, my lord. Yes, my lord.
So have you sent away your daughter to any other place?
No. She is with me. She is with IABL. She's directed me. I can produce before. I can produce before.
We will ask the police. You ascertain who is appearing for the state. Give him a notice and come back day after tomorrow. Give a notice to the police who is for the state. Ascertain who is for the state.
If you wish to, there is a civil dispute in between us.
Consider, let us ascertain, let the police, let the state advocate appear and tell us that your daughter is with you. Day after tomorrow. Can you ascertain which was the state in the meantime, or will we keep it next
My
Tuesday?
lord, I have to take some time, my lord.
Next Tuesday রাখো।
Keep your-
No, no, no one লিখে দাও। The
Appearing for the appellant.
57, my lord.
57
Yes, ma'am.
কি হলো 57
57, my lord. Miss Sushmita Shah is appearing for the respondent, my lord. She is suffering from high fever for last few days, my lord. I am praying for some more time, my lord.
নেক্সট উইক করে দিও, নেক্সট টিউসডে। Next Tuesday can come. This way the matter will not run in the list. What is the matter? You are appearing.
Yes, yes. The part where
Then let it go out of the list when you are not interested. You are interested to do the matter.
for the appellant.
Yes. No,
Every
you
time
are
we
not
are appearing, they took time. Last time also they took time.
What is the matter about?
Matter petitioner participate in the for the post of soldier general duty. There is a soldier general duty recruitment process initiated by the defense. Now what has happened in the recruitment process, in the eligibility criteria, there is a provision that those candidate who having the NCC certificate, he don't have to appear in the written examination, and petitioner my
Who
lord
is the advocate for your?
Miss Sushmita Shah.
Why she is not appearing
My lord,
repeated
she is
occasion?
suffering from high fever, my lord.
Then
for
you
the
should
last
get ready, na? If you
Then I got 200 out of 200.
repeatedly pray for
And he is
adjournment,
out of consideration.
sends a bad signal, na? Who is your junior? Are you her junior?
Yes, my
Are
lord.
you engaged in the matter?
No, my lord.
Then she is for the Union of India. She must be having a junior then.
No, my lord. No junior is there.
Then, madam, this way we cannot go on. This becomes embarrassing for us.
Last week also I appeared.
We are keeping it next Tuesday. If she doesn't appear, then we will accordingly proceed. This way it cannot continue. দেখো নেক্সট দেখো সব হিয়ারিং যেই আসবে না তখনই পেট ব্যথা মাথা ব্যথা এসব আসবে আর ইমিডিয়েটলি
Appear for the respondent number 2.
for conversion from GPF to EPF. On the last occasion, my lord, your lordship wanted to know as to whether the appellants are all in service or retired. Yes. Now only remaining three, all other persons are retired, excepting three. They are still now in service. Then your lordship's query was, what is their date of retirement? Without a date of retirement, it cannot be determined. Because in my appeal, my lord, I have taken a point in the writ petition as well, that well, there is a hostile discrimination between two sets of employees who retired and with us. Those who retired, some of them have been given this opportunity, even after the date of option given was long, long over. In our case, it was not accepted. So there is a hostile discrimination.
Now, who are the three persons in service? Have you?
Three persons.
Three persons are in
Yes.
service.
Three persons are in service.
And others who have retired, persons similarly situated with those persons,
yes,
have been given the benefit of
yes,
corpus.
And both the lists are there. But last time the controversy was raised as to whether the list of the retired employees of the appellants is there or not. Now, this is precisely a question my learned friend raised in his affidavit in opposition.
No, you are the individual employees, no?
Yes. We are the employees, retired employees, excepting three.
When did you retire, Mr. Ali?
Well, that was a question precisely asked by my learned friend in the affidavit in opposition.
Before the trial judge?
Before the trial, yes. And your lordship also wanted to know that.
So
it is very much there in the paper book.
So do we go through the order, or do you want to take us to the order of the single judge?
Yes. I've given the persons, those who have been given after retirement, a list, and the list of the retired employees, those who are the appellants, who have faced this discrimination. This is the case. Now, so far as the judgment, my lord, your lordship will catch the judgment. 182 of the paper book. 182 of the paper book.
I think it is 153.
153, sorry, my lord. 153 of the paper book. $153. Up to 152 is the name of the yes. Could I place it, my lord?
Or we may go through it, whichever.
Okay. May I take my seat, my lord?
Yes, yes. Yes, Mr. Yes.
Yes. My lord, in order to bring home to my point to your lordship, my lord, I have given copy of a judgment your lordship has delivered on such point. My lord, it is there in the brief, in your lordship's brief. This was the state of West Bengal versus Shubhendu Chakraborty and others.
Yes, yes, sir.
This is your lordship.
When did you all retire?
My lord, we are retired.
You retired. What are the dates, Mr. Ali?
Lordship will kindly take up.
All retired except 3, you said. There are
Date of
49 petitioners.
Our date of retirement.
Do you have a list to that effect?
Yes.
That is at page?
At page 139. Annexure P10. At page 139. But precisely that was the question that was raised by my learned friend in his affidavit in opposition. Yes. Now your lordship will kindly see another list that I have included. It starts at page 65. Page. It starts from page 48. Starting from 47, because it was upon lordship kindly goes to page 47.
47?
47 of the paper book.
Yes.
The retired employees. Well, this is final option in respect of death cum retirement benefit scheme. The retired employees, the inheritors, lordship will kindly mark this, inheritors of the expired employee, widow. That means widow have been included. Whether you can include the widow or not, that you have to see the scheme. Whether widow is entitled to a pension. Are being informed to the effect that the date regarding giving final option in respect of death cum retirement benefit for the company's employees has been approved by virtue of the order of West Bengal government dated 21st July 2006. All the existing employees, retired ex-employees, all the expired employees who died on 2/4/1997 or thereafter till date are included under this scheme. Widows included under this scheme. All the employees retired or the widows for the retired employees expired on 2/4/1997 or thereafter, who are willing to avail of this benefit are requested to collect the form regarding pension option from the person, from the pension office of the company as the aforesaid address upon production of voter identity card and so and so. Now the next page, your lordship, can you go? So I have drawn your lordship's attention to this particular notification in order to show that it is the widows and the inheritors will get pension under what? Under the regulation you have framed. Under the regulation you have framed.
The regulation came, it was notified on 24th December 2001.
Yes.
With retrospective effect from 97.
Very good.
So the circular says that the The retired employees.
This, my lord, I am not very much serious about this. I am only serious about this circular is you are given a widow and inheritors.
Of those
under your scheme. Under your scheme. If the scheme includes the widow, I am out. But if the widow in the scheme doesn't include the widow, can you extend the benefit? Can you create a new class under in this scheme? That will be one of the points. But now, my lord, we are asking, my lord, that well, a group of retired employees who did not extend their options within time have been given. Who are they? Already a long list has been given. I've given them, it starts from page 48 right up to শেষ পেজটা বলো একটা একটা করে কেন উল্টাচ্ছ yes
48 to 96.
96
48 to 96 are all retired persons.
yes and what is the heading your lordship sees at page 48? List of pensioners whose payment started after adjustment of the company's contribution and interest thereon.
So where do we find that they exercised options subsequent to 2006?
Pardon?
These persons, 48 to 96,
yes,
you said that a group of retired persons who did not opt within the time specified in this memo.
It says payment started after adjustment of company's contribution and interest. That is significant.
Yes.
Because in the scheme, it is stated. In the scheme, it was there that if you have failed to give your option and you are retired, even after retirement, we shall give you the pension provided you pay adjustment of company's contribution. That means they were in the.
Where is that circular?
What is that?
Where is this? Where is the document supporting this contention?
Scheme.
Supporting your contention.
Yes.
That irrespective of the date of exercise of option,
yes,
you will be given the benefit.
There is no controversy about it. There is no. It is not controverted. Lordship, kindly see. This is my statement. This is P7. Yes. This is annexure P7. Yes.
What was the date of their exercising of option?
They did not exercise their option.
They did not exercise option
because refund of the GPF only arises
after the transfer takes place.
Yes. Because they failed.
I think that
and
is
the provision,
not
and the provision in the scheme is there that if you have already retired and taken the money off of your GPF contribution, then pension can be given to you, provided you refund the entire money.
Yes, that is well settled.
That is there. Now, my lord, this is what it is. At page 16, your lordship, read paragraph 22. On requisition by one of the retired employees under RTI Act, a list of employees who switched over from contributory provision to pension has been supplied by the authority. It is apparent from the list of the employees who were to switch over that there has been irregularity in the process of extending the benefit in respect of years of retirement adjustment of benefits without following any uniform method. This is annexure P7.
That you show page 48.
Yes. Now, what I am aiming to show, under annexure P7 at page 48. Yes. Yes. My Lord, your Lordship kindly goes to page 113. Because that was what I have stated in paragraph 22 of my application.
Take within paragraph 12.
22, yes.
Page 113.
Yes, 113, paragraph 12. It is denied that the list of employees annexed as P7 of the writ petition show that there has been irregularity in the process of extending the benefits in respect of years of retirement. Adjustment. Denied. Denied. And how far this denial is correct, I'll come to it. No, this is what it is. But my Lord, let me place it. It is stated that the sage enlists the list of pensioners whose pension started.
Assuming, but
It is stated that the said list enlists list of pensioners whose payment started after adjustment of company's contribution interest thereon. The said list fails to demonstrate any irregularity as has been alleged by the petitioner's hearing. Assuming বুঝে যাচ্ছ
assuming but not admitting that there has been irregularity in extending. But such irregularity, even if does not make the petitioners entitled to option থেকে বাইরের option exercise করার লোককে থাকে while we not extending with
any irregularity.
we come back, Mr. Ali.
As your lordship.
আজকে দুটোই কিছু আছে নাকি?
I was on paragraph 12 of the affidavit in opposition at page 113. I was pressing from this place. It is stated that the said list enlists the list of pensioners whose payment started after adjustment of company's contribution, as has been contribution and interest thereon. The said list fails to demonstrate any irregularity as has been alleged by the petitioners herein. Assuming but not admitting that there has been irregularity in extending the benefit, but such irregularity, even if any, does not make the petitioners entitled to receive the benefits of the pension, especially in the light of the fact that the petitioners have themselves admitted that they were reluctant to exercise the option form. It is well settled principle law, Article 14 and all this has been stated. Now, my lord, one question is as to whether the benefit of such irregularity has been shown or not. Lordship will kindly now take the list of retired employees to whom the benefit has been given, starting at page 47, perhaps, yes. 40. Let me start with page 48. Page 48 on the one hand, and the list of the appellants before your lordships from the date of their retirement. So that list is at page 139.
Yes.
My lord, at page 48, whose payment started after adjustment of company's contribution in interest thereon. That is after their date of retirement. My lord, the date of retirement, for instance, say number 1. Date of retirement is 30th April 1997. He is being paid after refund of the same. Now your lordship goes to page 139. Monojendra Chakraborty is one of the appellants. He said, I have been discriminated. When did he retire? 28 to 2013. So in 1997 retired, his payment has been allowed after my lord reimbursing the payment that was already claimed. But in my case, I am not entitled.
But that is because he came within the period from 2497 to 24th of December 2001.
It is all right. But I was also in service.
No.
I retired
He
in
retired in
1923.
Yes.
2013.
Page 47 which you showed us, Mr. Ali, prior to this presentation, page 47.
Yes.
Page 47 deals with the employees who have retired post 1997 to 2001.
Yes.
And the date for exercising of option for coming into the pension was 31st of July 2006.
Well, page 97, 47.
47.
Yes.
Which you said that includes the widow.
Yes.
Are being informed to the date regarding final option in respect of DRCP for
the employees
by
retired.
virtue of this government notification 21st of July 2006. All the existing employees, retired employees, all expired employees who died on 2497 or thereafter,
and thereafter
till date, are included under this scheme.
Expired employees or thereafter.
Yes.
Or thereafter, who are willing to avail of
All
this
the
benefit.
employees retired or the widows for the
This is with regard to the collection of the form.
who are willing to avail of this are requested to collect form.
This is with regard to collection of the form. Collection of the form is another chapter to which, my lord, I have taken a point. Collection of the form. That was had to be notified. But here, my lord, I am that from the date of retirement, if there was any discrimination, a date of retirement, as your lordship finds in page 48,
That
because
you
the
have
date
shown
of
us
retirement is 97.
97 retiree has been given, 2013 retiree has not been.
Yes. 2013 not. It is like that. 2007, lordship, it is a long list because of all this. Yes.
Notification. That is 2001. সেটাই বলছি আমি 97 থেকে ওই ইয়েটাতে
This particular. Lordship, we can say that adjustment of company's contribution and interest thereon. There is a provision. There is a provision. Your Lordship will kindly come to that provision. Kindly see to that. Yes. It is, my lord, at page 32.
Yes.
Page 32. It is the scheme. Six. Your Lordship kindly see 6.
Yes. No, before that you place regulation 2.2.
Yes.
Page 31.
Regulation
2.2.
Yes, 2.2. The pension shall normally be treated as death cum retirement benefits admissible to employees who are on payroll on the company as on 1/4/1997. There is no discrimination between the two lists.
Let us read together.
And are on payroll of the company and remain on the payroll of the company till the date of actual notification of this regulation in the official Gazette of the Government of West Bengal.
So that is 2001.
Yes.
Now, they will get, so those who were in service on 1/4/1997 till 24 December 2001.
A class of employee.
Those class of employee will get pension in lieu of contributory provident fund. That's one. Next, but including the employee is permitted to retire under that is not.
We are not voluntary retirement.
That the pension rate shall be optional to the employees as in regulation 2.2.
It is optional, not a compulsory one.
Now 6.1.
6. Now I'm going to 6. The employee 6, my lord, your lordship finds at page 32.
Yes.
Employees who may prefer to come under the purview of this regulation, there is no distinction, there is no discrimination, there is no classification, whoever is awarded to. Employees who may prefer to come under the purview of this regulation shall have to exercise his option within 6 months. That is the date. You can fix up. Next, the employees who were on payroll of the company on the date on which these regulations came into effect and onwards, but required on subsequent dates, but before the publication of these regulations, may exercise their option within 6 months from the date of publication of these regulations, provided they refund to the company the full amount of the share of company's contribution towards contributory provident fund with interest accrued thereon plus an additional so and so, chargeable from the date of receipt of the company's share up to the month of preceding month of refund. They will, however, entitled to get the benefit of pension from the date they retired, and disbursement of pension shall be made only after they refunded the company's contribution of provident fund together with interest they received. Therefore, this is a provision, my lord, by virtue of which both, my lord, the employees at page 48 through 96 and they have been paid. They have been paid. Now, if we fall within that category, and if we are willing to pay the contributory provident fund in the amount that has been given along with interest, should we or should we not be allowed is the question. That is the question.
Read the next provision, Mr.
Pardon, madam?
Read the next regulation 3.
Yes. Now, a question was raised, but perhaps, my lord, that question will not be very important so far as, my lord, while starting the pension regulation, I mean this regulation, my lord, which is pension regulation, whether two classes of employees have been created. A question, my lord, that was agitated before the learned trial court by me. And in support of my case, my lord, I have cited, my lord, one decision.
Now, before that, Mr. Ali, kindly read 6.3 because they would be relying upon that.
6.3.
Yes.
Failure to exercise option as employee within the stipulated as referred to in regulation 6.1 and 2 shall be treated as if he had not opted towards the pension.
Yes.
If you have given it at page 47, they have not. Admittedly. Otherwise, you cannot accept the refund of the money.
They have given the option prior to this date of 2006.
No, where it is? They have not. If you give the option, then refund of the money a question doesn't arise. A refund of the provident fund which I have already received.
Yes.
In order to get the pension under the scheme.
Yes.
Therefore, this is all after they have refunded. That means they did not pay, they did not give their option.
No.
Had they give their option.
The option has to be given.
Yeah.
Or option has to be given, they will accept it. I will now go to the pension scheme upon refund of the excess CPF which I have received.
My lord, is that option to be given even after retirement? No.
Up to 2006.
After 2006 also has been extended.
No, that is.
That
we understood your point that irrespective of the last date
of exercise. In the opposition, it is not their case that they have given their option. In the opposition, they have not controverted that.
They say that if there are some mistakes to that effect, that cannot create any right in your favor. That is their argument.
Who will presume that mistake? It is they have to assert before the court.
Yes, we will hear.
They have to assert that, well, they did exercise their option. Now, if they have exercised their option, my lord, a question I can ask myself. If they have exercised their option, then what is the utility? That even after retirement you are paying the money? Refunded back the money? Because they have accepted. The contributory fund, they have already accepted. What is the necessity of the option? The option is that I do not want to proceed with the contributory project.
Yes.
I want to give the pension. If my option is there, then why would you pay me after my retirement and refunding back the contributory provident fund?
No, that option was not there, Mr. Adi.
The option was not there. The option was not there.
You did not exercise option. You have retired as a PF retired. Admitted facts.
But in my case, no. I am on this page 48.
We understood your point. You are a PF retired. You did not exercise option within 2006. Yes. You are trying to make out a case that when in terms of 6.2, you have given those persons upon adjusting, How you can create a second class? That is your argument.
My lord, that's my argument.
We understood.
Yes.
Now, yes, what more you want to show us? Division bench judgment?
Pardon, my lord. It's different.
You wanted to show us any other
Till
judgment?
my learned friend has taken shelter to a division bench judgment.
Yes, that
Coordinate bench judgment.
Yes, that Dilip said.
A coordinate bench judgment. Well, my defense is on that. Before the coordinate bench, that was not the issue, that there was a discrimination. That was not a question which the coordinate bench was called upon to decide. There is a sharp distinction between the coordinate bench. My lord, you will kindly forgive me, I am saying that, quote unquote, coordinate bench judgment. Yes, it was not a point. That was not an issue. It is a new issue, my lord, that I am calling upon this court, my lord, to decide. That is an issue which has not been decided.
That will not as a binding precedent.
So, my lord, that remains is still, it is not a res integral, no. It is not. So, my lord, this is my point also. Then another point I have said that, well, pension regulation is always, my lord, a beneficial and welfare legislation. Lord, you will kindly pardon me, my lord, I am taking this point to sum up. In other sphere. Pension regulation is, my lord, it is a welfare regulation, a beneficial regulation.
Yes.
Well, the people of this country, not only the court, are tired of hearing this, my lord, proverb that, well, India is a welfare state. It is a welfare state. Now, in the approach of the welfare state, yes, it did. That is why so many industrial regulations. That is why so many, my lord, industrial laws have been enacted. This was not there. But with the passage of time, after the independence, my lord, these welfare legislations were being adopted by, from time to time, by the authority, by the state. It is. And that pension is a welfare resolution is also judicially accepted on D.S. Nakara's case. I have taken that point, D.S. Nakara's case. The D.S. Nakara's case was cited before the learned trial court. Lord, you will kindly see the judgment of the. Well, before the learned trial court, my learned friend, took one point. What is that point? Well, these people, they did not give their option because they were calculating which will be beneficial, which will be more lucrative, whether pension or GPA. Is that a scene for me? Why? Was it a scene for me? And মহা পাপ করে ফেলেছিলাম আমি ভাবছিলাম after retirement which will be my benefit? Which will be my benefit? I have given an explanation. Lordship will kindly see, my lord. If it commends to your lordship, my lord, lordship will kindly see. In my application, in the REET application, lordship kindly goes to page 13. There are only 3 paragraphs I shall place, your lordship, for kind consideration. Paragraph 12, at page 13. Chapter 6 of the pension regulation that deals with the amount to be ultimately payable to the beneficiaries based on the formula as prescribed thereunder for arriving at quantum of pension was visibly arbitrary and illusory compared to flexible market behavior dominating individual decent living. That the amount of pension was kept static for years together without any increase despite continuous rise of price index, which made even the eligible employees reluctant to accept the pension, far less attracting for options. So that was one of the considerations. But why I am pressing this? Because an allegation has been made against these people were not interested to give. They were considering as to what will be the beneficial. Everybody sees for beneficial. Yes.
Yes.
Everybody sees for benefit. Whatever your lordship will kindly pardon me. The cavemen also saw their benefit, they came out of the cave. And the people here also see, look at the benefit where they will be more beneficial. Yes. It is in general human train. Cannot deny it. But why? It was kept static. Therefore, even the eligible employees are reluctant to accept the pension, far less attracting the pension. Is it not very obvious from the two lists I have filed? Well, the other people also, they did not exchange their option. To cite an example as submitted, case of Bharati Mukherjee, whose pension chart is annexed herewith, may have some relevance for discussion. It is apparent from the pension chart, pension amount of DA relief was fixed at 1694 and rupees 940 respectively between the month of August 2005 up to the February 2011. There was no price index which has taken place, most likely over that period. Similarly, these are the explanations that I have given as to against the allegation that has been made that these people were reluctant not to give their option. If for that I am a sinner, well, it is unto your lordship as to how, whether our sin can be condoned or not. Another question I have sent, well, you have said you are giving to the widow. Under your scheme, is widow entitled? A question I am raising for your kind consideration. My lord will kindly take again for a moment this scheme. Widow. I do not know whether widow belongs to the family or not. My lord, your lordship kindly goes to page 32. Page 32. Definition. This is definition part. Page 32. Resolution 7. Regulation 7. Lordship says, my lord. 5. Regulation 7 clause 5. Family includes the following relatives of a company employee. For the purpose of death gratuity, your lordship doesn't find widow anywhere. Nowhere is widow. One. Wife.
In case of a
Wife in case of a male employee.
death gratuity.
Wife is not widow.
No. For death gratuity.
Widow has a separate definition. Widow, yes.
Oh, Mr. Ali, it's for purpose of death gratuity. 5A, it says for the purpose of death gratuity. So wife in case of a male
gratuity,
right? So
that
wife
includes in there.
Wife in case of a male employee.
In the pension, my lord, it is included. A widow is given, my lord, the benefit of the pensionary scheme. It is not only gratuity, as they have said, they have given that notification.
That you have said in page 33.
Page 30.
No, that is page 47.
47.
That includes the widow. Given to the widow.
Well, page 47. Let us see.
Inheritors of expired employee within bracket widow. It is not a case that widows are not coming under the regulations. That we understood your argument. That when you are giving the widow.
Well, the widows are given pension not under any particular scheme. It is under a death cum retirement benefit scheme.
Yes.
Not on the death cum retirement benefit scheme. I am here, it is a particular regulation that has been framed. Is that regulation a substitute for the death cum retirement benefit? My lord, this regulation, my lord, is not a substitute.
No, what is your argument? That widow does not come within this regulation?
What I am trying to say, my lord, I have no grudge against that.
No, what is your argument?
My argument is this. Now, if, my lord, whether they are entitled or not, leave aside. If the widows can be given, have they given the option? Is it there that their husbands have to give the option? Because if option is the most criteria, that is the last criteria, that unless you have given the option, you cannot get this benefit of the scheme. That is the question I am asking. Well, you can include the widow. I have no grudge, but I am only showing that it is not under the death cum retirement benefit, but it is a particular scheme that you have framed, which you say that this is the pension regulation. Kolkata Tramways Company Limited Employees Pension Regulation 2001. For all purposes, it should be regarded as death cum retirement benefit. It is all right, but not TCRB scheme. Well, these are the two different schemes altogether. Well, I am beseeching your lordship kindly to consider of this aspect, that if extension has been given over to the benefit to the widows, to give the benefit, then in that case,
the purpose is to benefit everybody. It is a beneficial scheme. You have included the widows, and it is not a case that the widows are also required to exercise option. Whether their husband also exercised option also, that becomes immaterial in view of the list which you have given.
Yes.
This is your argument.
But if it is the only criteria that without option it cannot be given, it is not. It is not. Showing from these two lists I have given, showing from the fact that the widows are also given the benefit, even the heirs and successors are also given benefit, only on condition, but I am insisting on this, only on condition that upon refund of the benefit which you have given, which you have already received, along with an interest, the state is also reimbursed. That is what it is. Well, that is a question that came out before your lordship's consideration of. In another case, and it is this court's judgment, my lord, the division bench, your lordship judgment. I have given that. The judgment I got the poor access. It is there. Should I refer to? Yes.
You have given it to us.
Yes.
Anything else, Mr. Ali?
My lord?
Anything else you want?
No, my lord.
Yes, Mr. Mujumdar.
The scheme was made applicable in 2001 with a retrospective effect from 1997.
Excuse me for a moment. Another question was there, my lord, about a notification. About a notification, my lord, that was published in Anand Bazar Patrika. That is also there. If necessary, I will clear it.
Yes.
That the scheme envisaged that whoever is a new entrant from 2001, for him, he is compulsorily to be governed under the pension scheme.
Yes.
And option was only for those who were in service prior to 2001. Please come to the last line of page 31. Page 31. That's the regulations.
New entrants.
Regulation 4. Regulation 4. The pension regulation shall be binding upon the new entrants on and after the date of official notification. Just the previous regulation is. The pension regulation shall be optional to the employees as in regulation 2.2 above. So the time to exercise this option was enhanced from time to time or extended from time to time till 2006. And the last one being an all-encompassing, whoever is left out, he or she may apply, even inclusive of the widows, because they would have been otherwise entitled to the widow's pension.
So that was page 47.
That was page 47.
What was the date of this? 21st November?
The last option is page 45. Please come to page 45. 44 and 45 together. With reference to your letter, the managing director had requested the government to extend the time for the purpose of approval of the last date. With reference to your letter number so dated 3rd May 2006 on the subject noted above, I am directed to inform you that the Finance Department has agreed to extend the last date of submission of option on or should be before 31st of July 2006. This has the approval of the Finance Department Pension Branch.
You are for CTC. Who is for the state? State is not here.
Mr. Amol Shen. Mr. Amol Shen. Now please come to the next page, 2007 circular. Page 45. The government of West Bengal in their communication of 21st July 2006 have conveyed the decision for a revised option date for the existing employees of the company also for DCRB scheme. The employees who may prefer to come under the purview of the scheme have to exercise their option within 31st July 2006. Arrangements are being made for the option form at depot office. These are those who are willing to exercise their option is requested to collect their option forms and send it to the Chief Accounts Officer on or before 31st July 2006. But obviously the date is 2006, not 2007. It's a misprint.
So last date was up to
31st July 2006. Thus far and not beyond that. That's our case.
So did the list of employees at page 48, all of them exercised option? Then why you have stated in page 113 that assuming but not admitting?
We could not calculate all these, not all data. It's a case filed after 14 years.
So where you have stated in your opposition that all the persons in the list at page 48 has exercised prior to that date.
Please come to the sole allegation is there were irregularities in the list.
Yes.
Now, please, what's the nature of irregularities? No pleading.
But that.
Please come to page 113.
That statement subject to.
It is a denial that there has been any irregularity in the list. It is stated that the said list enlists the list of persons whose payment started after adjustment of company's contribution and interest thereon had to be that I exercise option within my service tenure. My pension payment will only be made after I retire.
No, but where is that all of them exercised option within 2006?
In fact, this is not even the allegation. Please come to page 16. And may I just read two paragraphs, 20 and 21. It is pertinent to pension that because of the, I'm sorry.
Paragraph 20.
20 at page 16.
Page 16.
1-6.
Yes.
It is pertinent to mention that because of ineffective and inadequate publicity, a good number of petitioners who had already retired had no knowledge of the circular of 24 July 2006. It is submitted at several years after the cryptic publication of the notice of extension of option in the newspaper. The petitioners reasonably construed that the respondent number 4 decided to extend the time for exercising option with an ulterior motive, sought to actually shower favor to a large number of employees to switch over to pension scheme from contributory provident fund for oblique purpose and with a sense of discriminatory move, leaving behind a large section like the petitioners. On requisition by one of the retired employees, a list of employees who switched over from CPF to the pension scheme has been supplied by the authority. It is apparent from the list of the employees so favored to switch over that there has been irregularity in the process of extending the benefit in respect of years of retirement, adjustment of the benefits without following any uniform method. That's the allegation. It's not a case run by the petitioners that even after the last cutoff date, there has been
no, Mr. Mojan, very good. But you show us that where is that statement that all in page 48 exercised option prior to 2006? Because that does not go in tune with your averment in paragraph 12. Because you said assuming but not admitting,
right,
and no negative equality.
But I say that it is denied. First is it is denied that there has been any irregularity. But the allegation in paragraph 22 does not suggest.
Mr. Mojumdar, as the court, we can always ask you.
Right, not paragraph. Not I was only responding to paragraph 22.
22.
In the writ petition. Page 16.
Their case was there was irregularity.
But what is the nature of irregularity? Not spelled out. Today I have got the list with some of the documents, not all. It's a 17 or 18 years old case now. Not all of them had exercised option within the time period.
Then why did you make that statement?
But the allegation is switched over from CPF to pension scheme. Odd applied in the first phase, 1200 and odd applied in the second phase. Why was the sanction of the finance department necessary? To work out a financial basket? The calculation of fund would be required from the government, and that's why the finance had granted an approval for the last extension on the request of the company. Today there are another 2000 employees waiting. And not this
argument, Mr. Mojumdar, that they did not opt, this issue that they did not opt, it is right that employees were waiting that which will be the beneficial one.
Because previously there was no revision of pension after 10 years. It came only after 2006.
Mr. Mojumdar, our last special bench judgment says that irrespective of date of option, you have to give to the widows also.
No, that's the Boyd's judgment.
Yes.
But that was against a consideration. That's two details. That was against an age and revision.
Sorry to intervene.
Why Abhijit Boyd has no manner of application, but I can cite that judgment.
Yes, yes. Now you finish your what is your latest? So your contention is simple that a date was fixed, you did not come, you retired as a PF retiree, we cannot give it.
And you consciously did not exercise your option. Extension is not a matter of right.
Financial obligation cannot be an alibi, Mr.
It's now after 2022 Supreme Court judgment. It has to be taken into consideration.
Justice Krishna said that. From then it is continuing.
He had always been in favor of the tenants till such time his own house litigation came into.
No, that whatever it may.
The 2022 judgment of the Honorable Supreme Court says financial position is one of the most important factors which have to be taken into consideration for the purpose of extension of pensionary benefits, including the switching over. I just point out what the judgment of this Honorable Court was.
No, anything else you want to point out, Mr. Majumdar?
Please see page 129 of the paper book. I'm sorry, 128. But the fourth last line of that page. 1,772 existing employees opted for the pension regulations. The time to exercise option was extended in 2006. The last date to exercise option was 31st July. The Learned Council pointed out that 1,257 employees exercised their option at this stage. Then we're keeping about two sentences.
That was in 2006.
First phase, there were 1,772 applicants. Second phase, 1,257 applicants.
Where is that first phase you said?
Just the previous page, 128. The
1772. Next phase was this. Yes.
And the second phase took into consideration retired employees, even the widows. That was done on a special request or a persuasion made by the managing director of the company to the government. But a refund of employer share of provident fund contributions with interest.
This is beyond your regulations. Widow issue.
This was in relation to, this is a beneficial. This was beneficial to the employees, they had opted. And in relation to their deceased husband's pension.
Yes.
Now please come to page 130. I'm sorry, page 129. It's almost in the middle portion of the page. The sentence begins from the right hand side of the line with the words, this requirement to exercise the option. 8th or 10th line from the top of that page. Page 129. 9th line.
Yes.
This requirement to exercise their option was for all the aforesaid categories of the employees, and the appellants having failed to exercise their option cannot now demand the payment of pension. He submitted that all the employees have been paid their provident fund dues, including the employer's contribution and the gratuity and other retail benefits. Then please see the next paragraph. We have given our anxious consideration to the submissions of the Learned Council. There is no dispute that the pension regulations were notified in 2001. Therefore, the appellants cannot feign ignorance of a notification once it is published in the official gazette. But ignorance of law is no defense or excuse. Please come to the next page. This means that by June 2002, the existing employees had to exercise their option to avail the pension regulations. 6.3 explicitly provides that failure to exercise such an option within the stipulated period would mean that the employee had decided not to opt for the pension regulations. Thus, the appellants cannot claim that they were not aware of the pension regulations. Further, the circular issued on 24 July 2006 also extended the period to exercise the option till 31st of July 2006. This was followed by a newspaper publication. The submission of the appellants that there was no publicity for this scheme is untenable in view. A similar allegation is made in this writ petition also, of the fact that the pension regulations were notified in the official gazette. Not I skip over the judgment. Then
where you are reading?
Not the
that the circular issued on 24 July.
Second paragraph of that page.
Yes,
the first paragraph.
also extended the period to exercise till 31st June.
This was followed by a notice in newspaper publication.
Yeah.
Intimating all employees, existing as well as retired employees and the widows of the deceased employees. The submission for the appellants that there was no publicity for this scheme is untenable in view of the fact that the pension regulations were notified in the official gazette. The reliance placed by the learned counsel on so and so is of no avail. The pension scheme in both these judgments was notified by circulars which the Supreme Court found that had not been published or communicated to the employees. In the present case, as we have mentioned earlier, once the pension regulations were notified in the official gazette, the appellants could not claim that they were not aware of the pension regulations. There is no doubt that right to receive pension has now been considered as a fundamental right by the Supreme Court, as pension is the property of an employee. However, when a scheme for pension is made applicable to existing employees, conditional upon them opting for the same, and such option is not exercised within the stipulated time, they cannot claim the pension as a matter of right. The pension is payable under the pension regulations which have been notified in the Gazette. Since the appellants chose not to exercise their option within the time frame stipulated in the pension regulations and as extended by the CTC, they are not entitled to claim the pension under the aforesaid regulations. Please see the last 3 lines of that page. Therefore, in our opinion, the appellants have no right to claim the pension at this stage when they have not cared to opt for the pension regulations while in service in the year 2001 or within the extended date of 31st July 2006, more so when all of them had received their gratuity and provident fund dues on retirement. I'm not why the The Honorable Supreme Court has now repeatedly laid down that fixation of cut-off date is not arbitrary, if it can be explained. Please come to paragraph 5 of that report. 2022 for SCC 193. No, page 193. Grant of pensionary benefits to the employees of the grant-in-aid institutions, etc. came to be discussed in the meeting of the Cabinet of Ministers held on 30th of January 1997. After due deliberation, the Cabinet approved the proposal to the effect that no pensionary benefits should be granted to the employees working in the institute receiving grant-in-aid corporations, etc. But thereafter, the Governing Council in its 44th meeting held on so resolved to send proposal to the government to grant pensionary benefits to the employees of Valmi. The then Director General of Valmi issued a communication of 2000 to the Secretary and gave his opinion in affirmative for grant of pensionary benefits to the employees. But the government, through its Finance Department, issued a resolution of 2005 and introduced a new contributory pension scheme for the government servants who are recruited on or after 2005 in the state government service. On 8 November 2005, the state government, through its Finance Department, issued another resolution and resolved that the employees serving in grant-in-aid institutes, mandals, corporations, etc. are not entitled for grant of pensionary benefits, and the pension rules shall not be made applicable to them. Again, the Director General issued a communication dated so and so and prayed for a grant of pensionary benefits to the employees by communication of 2012. The Finance Department of the state again reiterated that the employees are not entitled to pensionary benefits. Then please come to paragraph 8. Hence, some of the employees filed a writ petition of 2012 before the High Court at Bombay. The High Court directed that the state to take a decision on the proposal of 2008 within a period of 6 months. With a communication of 2013, the state informed that the request for grant of pensionary benefits to the employees has been rejected. Feeling aggrieved and dissatisfied of the communication of so and so, rejecting the proposal or request for grant of pensionary benefits to the employees, the ex-employees and employees of Valmi preferred the present writ petitions and prayed to direct the state to grant pensionary benefits which are available to the state government employees also to the employees of Valmi. Now please turn over straightway to paragraph 28.
Yes.
As per the settled proposition of law, the court should refrain from interfering with the policy decision which might have a cascading effect and having financial implications. Whether to grant certain benefits to the employees or not should be left to the expert body and undertakings, and the court cannot interfere lightly. Granting of certain benefits may result in a cascading effect having adverse financial consequences. But that's why not the finance approval was taken while extending the time period for exercising of option. Now turn over to paragraph 31.
Yes.
Now, so far as the observations made by the High Court that the amount available with Valmi and deposited with EPF towards the employee's contribution itself is sufficient to meet the financial liability of the pensionary benefits to the employees, and therefore there is no justification or reasonable basis for the state to refuse to extend the benefit of pension to the retired employees is concerned. It is to be noted that merely because Valmi has a fund with itself, it cannot be a ground to extend the pensionary benefits. But in our case, we don't have the funds. Even grant of pensionary benefits is not a one-time payment. Grant of pensionary benefits is a recurring monthly expenditure, and that is a continuous liability in future towards the pensionary benefits. Therefore, merely because at one point of time, Valmi might have certain funds does not mean that for all times to come, it can bear such burden of paying pension to all its employees. In any case, it is ultimately for the state and the society to take their own policy decision whether to extend the pensionary benefits to its employees or not. the interference by the judiciary in such a policy decision having financial implications or having a cascading effect is not at all warranted and justified. But after every 10 years, there will be a financial impact. It goes without saying that this corporation depends almost 95% on state grant.
But why do you say Obijit Goitto is on a different?
That was the case, not where along with the pay revision order came not certain benefits. One who would not exercise that option would be automatically getting the benefits. That was the language in that scheme. A pay revision order with certain age enhancement facilities.
Thank you.
These are my submissions.
Well, certain points of the learned judge, my trial court, my learned friend has referred to, and also a Supreme Court judgment.
Oh, and the other judgment, not which Mr. Ali had relied upon, that State of West Bengal versus Shubhendu Chakraborty.
Yes, that we had.
But a 2022 writ petition was filed.
There before you.
Yes, we have it.
But there the employer had recommended in 2018 Please come to internal page 4 of that judgment. In the paragraph beginning with the words, Mr. Talukdar, learned advocate appearing for the KMDA, submits that the decision adopted in the 181st meeting on 23rd February was confirmed in 182nd meeting of 25th May 2017. Drawing our attention to memoranda of 2017 and 18, he submits that the KMD authorities made a sincere endeavor to avail necessary approval from the Finance Department upon answering all queries, but in vain. There had been no lashes on the part of the KMD authorities. Skipping over the next paragraph, in the DCRB regulations, it was stipulated that an employee who retired after 1st January 1986 and who is in service and is willing to come under the said regulations shall exercise option in writing in Form A within 6 months from the date of issue of the notice on behalf of the authority. The period towards exercise of such option was extended from time to time thereafter up to 28th February 2022. So there was an invitation open till 28th of February 2022 and writ petition filed in the same year. As the relevant regulations and guidelines were not appropriately circulated, the writ petitioners failed to exercise option. That was the finding. However, such issue was considered and the KMD authorities approved the proposal for inviting fresh option since employees similarly situated had been extended the benefits.
All right. Mr. Ali, you reply on a particular date because we have another fixed matter now.
Not today.
We are keeping it on another day. Tell us when we will keep it. He has finished. Ask your junior to give a notice to Mr. Amol Sen also. The state. কবে রাখবো বলুন তো? এই তুমি কটার সময়? Heard Mr. Ali.
My friend has concluded his argument. My learned friend concluded his argument.
Yes.
Yes.
Heard Mr. Ali Lanet Senior Advocate appearing for the petitioners. Mr. Mojumdar Lanet Advocate appearing for CTC has concluded his arguments. Today, however, no one appears on behalf of the state respondents. Who is appearing? কে দিয়েছে? কেটে দেবে, কেটে দেবে. No one appears on behalf of the state respondents. and since and
junior achievement. May, perhaps.
Yes, 7th, হ্যাঁ কবে?
হ্যাঁ
না না সেটা তো এখন শুনবো, 8 তারিখ তো কিছু নেই আমার।
Well, 7th is those all those big matters.
That is 7th.
But no,
ওইটাই বলছি 7th primary, 8th we have kept.
8th.
Or you want to come next week?
Next
Please. 8th it will be there, Mr. Ali. You conclude and give ask your junior.
I will give that notice. Yes.
Yes.
I'll give that notice. He was here he was always here. But anyway, I am apprehensive but not 7th, perhaps 13 or 40 matters.
8th রাখবেন 8th
আমি বলছি 7 তারিখে গুতোগুতি মারামারি হবে কিনা।
ও আচ্ছা
Hopefully we will be safe.
Hopefully we cannot go out even today. Yes.
Or we can keep it on some other day if you are in.
এতে যাওয়া যাচ্ছিল না ভাই।
8 তারিখ অবশ্য বৃহস্পতিবার, তারপরের দিন ছুটি পড়ে যাচ্ছে। At 2 p.m. ঠিক আছে, 14th at 2. Yes, Mr.
Just before I just start the
Mr. Bandyopadhyay, how long will you be taking?
20 minutes.
Because we have to rise a bit early today. At about
3:30 your lordship will like.
Yes, at about 3:50 we will.
I will finish it. Only one thing, that before I start the audience side matter, that point I was arguing that the clause 17 of the that has to be read as a whole. Statute control order has to be read. This order has to be read as a whole, not a particular provision. That I argued, lordship.
Yes.
In support of that, only one judgment.
Yes.
I am giving Miller. That is 2002 volume 2 Supreme Court cases, page 318. Then I will just begin.
Appellate matter taken আছে তো?
হ্যাঁ বল না। Just এই judgment টা দেখি তো।
তুমি এই ফাইলটা
paragraph 11
এই ফাইলটা দাও। ওই appellate সাইডে আমার নোটের ফাইলটা ছিল এখানে।
paragraph 11
That no particular clause cannot be taken up in isolation.
Yes, as a whole it has to be taken.
Paragraph
11, my. I do not want to read, but just a lot. Paragraph 11.
With the note. এটা কি আলাদা রেখে না হোল্ড করা নোট আছে না?
This is the only. Now, kindly come to the original side.
Before my learned senior friend starts. Item number 1. Before my learned senior friend starts, may I submit only 2 things, my lord?
What?
And my learned senior friend has argued on the basis of our appeal.
That matter we are not hearing. reply, Mr. He will give.
I'm not just telling the one fact, man. My learned senior friends has argued till today on the basis of the appeal preferred by us and the judgment. My learned senior friends clients also filed a cross appeal.
Yes.
So far, cross appeal is concerned, I have some objection to that effect, man. Cross appeal is concerned.
So give it to us on reply. Ask Mr.
As well as.
Let him finish on the original side matter.
As well as.
Now, my lord, so far the order impugned in this appeal, your lordships kindly come to
Mr. Bandyopadhyay, you were in Sitara in the appellate side.
Yes, yes.
Now, who are the other counsels in other matters?
I don't know, my lord. I am only arguing.
Respect of my lord.
In respect of the other line of matters in the appellate
State
side.
is the only respondent.
State is the only respondents.
Who is state?
Then Mr. Bandyopadhyay.
Mr. Bandyopadhyay.
Oh, yes, Mr.
He argued the matter, my lord. Same points are in all appeals.
Yes, what you are showing here, Mr.
My lord, the order impugned in the appeal itself. My lord, kindly just I start from there. Kindly see page 15 of the leave to appeal. This order was there.
Page 14.
Page 15 of the
Stay
leave to
application.
appeal.
No, leave
No,
to appeal ta kothay?
leave to appeal is there. Leave to appeal. This.
No. Eta dekho leave to appeal ache.
Anyway, my lord, whatever your lordships are looking into the order.
Leave to appeal application is not. It was
We
here.
have filed the leave to appeal.
Sujata Mitra, memo of appeal to order against it.
Lord, kindly see the memo of appeal. If the order is there, your lordships can see from there also. There is no problem.
You are appearing for.
I am appearing for the read petitioner in there. Here I am responding.
Sujan Rai.
Sujan Rai moved the read petition. Na? Now, I will show to your lordship first what is the order and whether in the order itself I have stated about everything or not. Can you do that? There is an allegation, suppression of facts, etc., etc. Now, let's see the instant read petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner. My lord, got it? In respect of the vacancy of distributor.
No, just a moment. We are not getting. দেখো লিভ টু অ্যাপিল আছে কিনা বলছেন উনি লিভ টু অ্যাপিল আছে
Must be it is along with the grounds of appeal.
Yes.
Now the instant read petition, my lord has got it. This is the order has been challenged before your lordship. The instant read petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of the vacancy of distributor at block Raiganj under subdivision Raiganj in the district of Uttoni. In the case of the petitioner, that the deputy director license DDP issued a memo dated 8 January to the contending interlayer in connection with the F&S department number under reference on the caption subject. The undersigned is directed to inform him that after due consideration as per control order, application for distributorship license of Shri Sujan Chandra Rai has been approved by the Food and Supply Department, Government of West Bengal for engagement as MR distributor against first vacancy at Raiganj block, Uttar Dinajpur, so and so in the operation. But in view of the interim order of this Honorable High Court in the matter of WPA number 1151 of 2023, that is Sujata Mitra and another versus State of West Bengal, license in favor of the approved applicants shall not be issued till disposal of the writ petition. In the case of the petitioner, then this was challenged. We have come before this court. It is the case of the petitioner that an interim order was passed in WPA 1151 in view of the pendency of an appeal MAT 296 of 2022. That's similar to the judgment of the justice standards. The 2022, the said appeal has been dismissed and disposed of. Now, Mr. Bandyopadhyay, learned senior advocate appearing on behalf of the petitioner, submits that there is no embargo to issue license in favor of the petitioner as there is no such interim order for issuance of license in favor of the petitioner. Mr. Bandyopadhyay also fairly submits that by virtue of decision of a batch of petition passed in WPA 2281/2022, an appeal being MAT was preferred before the Honorable Division when an interim order was passed by the Honorable Division Bench for not to delink any dealers from any distributors. My lord, allegations were made that I have not placed this order. I did not inform the court about this order. These allegations are incorrect. I have placed it. Now, my lord, Mr. Bandopadhyay submits that the present petitioner is not a party to the proceedings. So, the interim order passed by the Honorable Division Bench in MAT 1543 of 2000 is not effective upon the petitioner. Mr. Sonal Sinha, learned counsel appearing for the state response, submits that the authority concerned has already taken a decision for issuance of a license in favor of the so necessary order may be passed. That is the stand of the state. Having heard the learned counsel for the parties, it appears to me that the impugned memo dated 8 June to specifically restrain the petitioner for issue of distributor's license by virtue of a pending interim order passed in WPA so and so. The interim order in W was passed by virtue of a pending appeal being MAT 296 to this said appeal was dismissed and disposed of. Video order dated 18 January to the thus there is no legal impediment to issue license in favor of the petitioner. The petitioner is not a party. Honestly, the petitioner is not a party to the appeal being MAT 143 of 2024. That means before Justice Joymallo Bagchi. Thus the interim order in appeal is not binding upon petitioner. This is a finding. I am not a party to that. That is a Sitara Begum and others case which are there. Under the with instant writ petition is disposed of with a direction upon the concerned author to issue license in favor of the, according to the provisions of law. But this is the order is impugned. Therefore, your lordships can find from the two things very important is there. One thing is that pointed out the earlier appeal, WPA, that appeal which was disposed of by Justice Tandon, the appeal has been dismissed. My lord, kindly take note of this fact that only showing this order of the appeal, 100 petitions, they have got the interim order first. First round of interim orders. Showing that the Kataruka, just Kataruka and Kataruka. I am saying that for 5 or 6 years, everything is stalled. Everything is stalled. Somewhere one interim order is taken, that is applicable to 100 and 200 petitions. Now, Millard.
No, showing the order passed by Justice Tandon.
No, this was originally order, interim order was.
MAT 296.
Yes, originally the order was passed by Mr. Justice Sivanganam along with as a puny judge. That there was an interim order that no steps should be taken in the matter. And I will come to that, beloved. Just I will come to later on what was the subject. How the court has been, with great respect, has been misled by the writ petition. I will tell your lordships, beloved. Now, Kataruga, I will come to that later on when I will deal with this matter. Therefore, showing that the moment it has gone, the moment order has gone, now showing. You see, there is an order of Justice Joymallo Bagchi, another matter, because that interim order cannot be no more enjoyable. Now showing this 100 petitions, 100. So
that second appeal which you are saying of that is MAT 1543 of 2020.
22. Well, that is which your lordship is hearing the matter.
No, that is 296 of 2022.
296 of 2022 is different. 296.
Justice Tandon passed the last order.
Last order. And this is the appeal of
in which Setara was not a party. Which one is that appeal?
No, Setara was a party. It is applicable to Setara. Setara is not here.
Oh, achha.
Setara is not here.
Oh, that is Sujan.
Sujan was not here.
Sujan. Setara is not here.
MAT 1543 of 2024.
Yes.
Appeal was heard by Justice Bagchi.
Yes, there the interim order was there, which is now being heard by your lordships.
Yes.
Therefore, it is not that I have not pointed out. I have pointed out, court has also come, this interim order is not, I am not a party to that petition, this interim order is not applicable. Court has passed. I am coming one after another. And they were aware that they were not enjoying any interim order. Just, Millard, give me 5 minutes time. First, Millard, kindly see, interim order passed in his matter, 19 January 2023, That is page 14. Page 14 of the stay petition. Right, so stay petition.
Yes.
Page 14. Yes, page 14. See, affidavit of service filed on behalf of the petitioner is taken on record. All the parties are represented, heard the learned counsel for the parties. It is pointed out on behalf of the learned counsel for the parties that the same issue is being, my lord, kindly see. The same issue, which is the issue in the writ petition, the same issue is being deliberated upon by the division bench of so and so. The next date in the case has been fixed on the month of February 2020. Let the matter come up for hearing in the list, and the parties shall be at liberty to file written notes of submission in view of the taken points taken by the petitioner under the Central Control Order 2005. There is no provision for a distributor. So let the respondent not finally appoint any candidate in respect of the vacancy notification in question. However, there shall be entitled to otherwise proceed with the selection process. What are the points were taken in that appeal? My lord, kindly similar. Come to page 48. Shakuntala Devi Kataruka. But just give me, I am giving you, lordship, one background of this matter. I am giving one background of the matter. Just giving one background. This Sonali Food Marketing Private Limited, my lord, moved a writ petition. In the writ petition, it was alleged, the challenge was that company was not allowed to be a distributor, to appoint as a distributor. Single bench dismissed the writ petition. Then the appeal court, single bench appeal court, the presided over by Justice Banerjee, held it, no, company is a completely different entity. Therefore, company can be a dealer, distributor. But following the judgment, one of the judge had delivered a judgment in the writ petition. Same company matter, that is the Sonali Food, moved a writ petition. One of the learned Singh judge, following the writ petition, they have allowed it. What has happened thereafter, Miller, when this has happened? This Kataruka, Shakuntala Devi Kataruka, moved a leave to appeal and said, you see, under 2015 control order, whatever the argument have been made, that it was a subject matter in that leave to appeal. Entirely that was the subject matter of the leave to appeal. All points. Ultimately, Millard, it came up before Justice Tandon. Division bench presided over Justice Tandon. Kindly see, Millard. Your lordships will find that little preclude, all the facts have been said. Millard, kindly come to page 52. Third paragraph. We therefore cannot countenance the submission of Mr. Shahar that he should be given an opportunity of hearing at the time of considering the application of the respondent number. Having given an answers concerning the issue raised before us, the first and foremost point involved in the instant appeal relates to locus of the appellant as person aggrieved in the context and perspective of the impugner. The notification dated 16/2000 embodied with certain itself condition as eligibility criteria for the purpose of so and so incorporates so and so. Miller, kindly. By this, we therefore need not, Miller, kindly come to page 53. First, second, we therefore need not venture to go into the aforesaid aspect and proceed to decide the point locus treating the respondent number 1 is otherwise eligible as a company to make an application under the aforesaid notification. The point which is urged by Mr. Sinara related to the satisfaction of the condition imposed in said notification, and according to him, there are cogent materials available with his client which would be sufficient to dislodge the claim of their having offended one or two of the conditions incorporated then. We do not think that the ultimate decision taken in the impugn order has foreclosed the right of the respondent, nor it closes the doors of the authorities in not consider application of so and so. Now, this last since no decision has yet been taken, the right of the appellant does not appear to have infringed, and therefore the plea of person aggrieved does not appear to be sound and logical at this stage. The consent of person aggrieved originates in a principle that if an order is passed in a proceeding between the litigants affecting the right of the third party who is not included in the proceeding, then third party may assert the said before the High Court. The agree has to be judged in this transfer. Merely a proceeding is initiated and the ultimate decision does not affect the right as no final decision has been taken, as in the appellant cannot be said to be a person aggrieved to maintain an appeal as a person aggrieved. Since all the points were kept open, including the point of locus, and having held that the applicant does not have a locus to a person aggrieved, we do not venture to decide the other issues raised in the instant appeal. We have been given to understand that several litigations are pending in the docket in this court in relation to a distribution within the state of West Bengal on various grounds, which have been taken in the instant, which have been taken in the instant appeal. Therefore, it would be appropriate to record that those points shall not be treated to have been decided by us in the instant appeal, implicitly or expressly, since our judgment is restricted locus to answer appellant to maintain the appeal as person aggrieved. Therefore, all other issues are understood and kept open, and if taken any other proceeding, be it collateral or otherwise, shall not be construed to have been implicitly decided as in the. Since we held that the appellant is not a person aggrieved, in view of the nature of the ultimate decision taken in the import, the leave to file to appeal is rejected. Now, who was the appellant, my lord? Appellant was Kataruka, not the Sujata. What they did, you see, I have taken the point there. Court has passed an interim order. Therefore, in all writ petitions, this same interim order would be passed. Nothing will to do with the Kataruka. And Kataruka is, my lord, kindly see, Kataruka, incidentally, later on not has come into the picture to file the challenge by appointment or the notification. And a unique procedure has been adopted in this matter. Very unique procedure. Rightly or wrongly, with great respect to the honorable judges, the court, without looking into anything, order, interim order, order, interim order. Now, kindly come to me, Lord. Page 19, Milord, is my writ petition has been.
Yes.
Milord, page 19 is my writ petition.
Yes.
Now, Milord, vacancy was in 1st September 2022. This vacancy was challenged in their writ petition. And in that writ petition, following that the order and the challenge which was in the Kataruka's case, interim order was passed. Because same Mr. Justice Joy Sengupta has said, the points which he have referred to, that was the points were in the Kataruka. Now, my lord, kindly see.
You were a party to that same?
No, I was not a party. This person was not a party in anywhere. In his writ petition. Yes. Now, vacancy has been declared. Now, when the vacancy has been declared, only challenge the vacancy, court has said continue with the proceeding. When continue with the proceeding, was it not proper for them to make the persons a party who have participated in the proceeding, in the selection process? Nothing has been done. Interim order was there. Then, Milord, my engagement, kindly see 8 June 2023, page 45, which I have quoted in the order itself, page 45.
That was kept in abeyance due to this interim order.
Yes, that was. Now, Milord, kindly come to, already I have shown to your lordship, Justice Tandon's order, I have shown to your lordship. I do not. Now come to Milord, 2nd August, page 56. This is Justice Bivas Pattanak's order. Milord, very interestingly.
No, Mr. Bandyopadhyay, when page 45 the state said that we are not approving license in favor of the applicant shall not be approved till the disposal of the
Now, after the dismissal of the writ petition, after the dismissal of the appeal, court, they have changed their stand. Now we will give the license. That has been said.
Then you ought to have made him a party in your petition.
Which one?
In the before Justice Bivas Pattonayak, which order?
No, Bivas Pattonayak order is not there.
Sorry, that is the order.
Justice Samanto.
Justice Shubhendu Samanto.
Justice Samanto.
In that, you did not make them a
no,
party.
He did not make me party. I did not make him party. No, that is a factual
So
thing.
then this fact was not pointed out to the court that in the earlier writ petition by virtue of which the license was withheld, that is the license of Sujan, this was not brought to the notice.
Of course it was brought to the notice. Kindly come to the order.
Page 100.
Order 30th January 2025.
Page 100.
Kindly read it.
Yes.
The instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petition in respect of the. Is the case of the petitioner that the deputy director license DTT issued a memo on 8 June 2023 containing interior memo dated 8 June 2023.
Last paragraph.
Yes, therefore it is pointed out to the court. Your lordships were making the observation. I have not pointed out to the court.
No, but being conscious of this fact, then that person ought to have been made a party to this petition.
We have not been made party also.
No,
now he is getting a whole opportunity to be heard.
Then what happened in review when this fact?
I am coming just, since your lordship has said that I have not pointed out, it's not correct. It is pointed out.
No, this is correct that you have not made him a party.
That is a different part. But it is not pointed out, it's not correct. This is some observation. Kindly
right, that memo is there.
Excuse me for this expression, Miller, my expression. But it was pointed out. It was pointed out, this order was pointed out. Pointed out, the Justice Tandon's order was pointed out. Justice Bagchi's orders were pointed out. 3 facts were pointed out. Court has passed an order. My lord, after all, Miller, 4 years, 5 years, we are not getting.
Yes.
Now, what has happened, your lordship, kindly see. When I have moved this, kindly see. Milord, and again I am saying, Milord, unique procedure is being taken in these sorts of matter. When the court is saying, give me the matters, bunch of matters, what do we want to be heard? When a bunch, on the same point, it is heard what the court says. Give me the list, what are there. Normally, court does it, and it has been done. See, in the Bivas Pattonayak, Justice Bivas Pattonayak, 56, come 56. Come 56.
Yes.
So many writ petitions were heard, but they did not bring it in the knowledge of Justice Bivas Pattonayak. This is the writ petition my pending. And all points which he has argued, all that points were decided by Justice Pattonayak.
Very good, very good. Now, what is your argument in this writ petition?
I am coming. I just give it. Give it 10 minutes. Now, representations, status quo, etc., order was passed. Now, they were aware about the facts that the interim order was no longer there. Which fact has been suppressed before the lordships? Give me the affidavit. Take my affidavit.
Which interim order was not there?
The interim order was passed by the Justice Samanto, or the writ petition, Justice Joysen Gupta, was no longer existing. My case was, it was no longer existing. His case is also no longer existing. That is the reason he has filed an application for appropriate order.
So why did you say it is no longer existing?
Because of Justice Tandon.
Because of Justice Tandon.
Because of Justice Tandon. Because of Justice Tandon, it was no longer existing. Why I have not made him read party? Because according to me, no interim order was no longer existing. And his case is also no longer existing. I am showing you a lot, which have not been said, suppressed in the stay petition.
So they filed an application for.
পরে
They filed an
যখন কোর্টে মামলা করেছি তখন বলেছি, যখন তারপর বলেছি না 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 প্রথম দিনই আমি অবজেক্ট করেছিলাম। জাস্টিস মিত্র ওয়াজ টেকিং এন asking you question, why did you not inform, why did you not tell the court? Thereafter you come up with a supplementary affidavit. Then your senior came and that Mr. he came and then he said, yes, I am coming to a very straight way. Milord, applications for appropriate order was filed by them before the learned single judge. Kindly come to page 23.
With the application to
Hey, opposition, give the opposition. I have not made in party, your lordship is correct, Milord, but I have my reading was that he was not there was no interim order that I should pass make him party. See, Milord, it starts from page 23. My lord, I will not take much time since your lordship has said your lordship early have to rise. My lord, just take note paragraph 8, paragraph 9, paragraph 10, paragraph 11, paragraph 12. Now come to the prayer. Now come to the prayer. In the aforesaid circular, your petitioner most humbly prays that your lordship may be graciously pleased to issue an order to issue reimposing the interim order. Reimposing the interim order, staying the vacancy declaration notice dated 1st September 2023.
Yes.
Therefore, he was also clear there was no interim order in his favor. And I was in an interpretation, there was no interim order existing. Therefore, I have not made him party. And he is very clear in his application, reimpose the interim order, because interim order was not existing.
Yes.
Now consider, Milord, one aspect of the matter. This application is still pending. Is the appeal maintainable now?
Now this appeal, they went up in review against that order of.
No. Review, in my petition, the review has been filed. The review has been dismissed.
Very good. Now the review has been dismissed. Now this appeal which they have filed before us, that is against Justice Samanto's order.
So both the orders were Justice Samanto.
Review as well as
Review both the order.
Both the orders are before us.
No, both the order, not the first order. Review, they have
First
not
order
preferred
review.
any. They have preferred an appeal. Therefore, in a case, in a situation when there is no interim order, kindly just I am making it very short context, I am taking it. In a situation where the no interim order is there, which is clear to the writ petitioner itself, according to my interpretation, there was no interim order. It was moved before the single judge. Single judge has said the interim order is no longer there. Give the appointment, and state has said we are ready to give appointment. What is the fault? What is the illegality? What is the illegality? Question is legality and illegality. One cannot approbate and reprobate. I have made these submissions. You have made an application, and one of the interesting paragraph. paragraph 11 of
Ticketing application. Yes, paragraph 11.
that is my earlier paragraph, the reference of the order of Justice Bagchi's, I mean Sitara Begum's. Then he says, your petitioner says that similarly placed and circumstanced person should be treated equally and your petitioner cannot deprive from the same relief. In such a discriminatory, your petitioner represent insurance was taken up for hearing by just one time when his lordship of the file the application. Now see this. Therefore, what he is asking for, he should not be treated as a in a discriminatory manner. Same order of Justice Bagchi which has been passed
Should apply.
should apply. Therefore, you impose, if the interim order was existing according to them, because then the question of filing of this application did not arise.
So the maintainability of the appeal itself becomes doubted.
Yes. And your lordships will find that in the stay petition, this has not been disclosed. On the very first day when it was taken up, I have pointed out. There is an application is there, pending is there. And now not right, and just kindly excuse me for repetition, just to make it very short, I will complete. 2 minutes. What is the illegality? If the order is patently illegal, in a mandamus, when an order is patently illegal, I will give a judgment. I have not brought the judgment today. I will give the judgment in a mandamus appeal. When court will interfere, if it is patently illegal, some illegalities will not do. Is not sufficient. I'll give reference the judgment on the next day. My junior will give it. It's a patently illegal. Now, is it patently illegal? When an order, he has obtained an order showing justice standards order. Justice standards order, court has passed an order. Court has passed an order, interim order. Earlier interim order. That interim division bench dismissed the petition, interim order has been vacated. If the interim order has been vacated, it is gone. And he knows that there is no interim order. He is filing an application for reimposing of the interim order. Then there is no interim order. If there is no interim order, what is the wrong the learned Singhania has done in my case, directing the state to give the license? Obstruction was nothing. Obstruction was interim order. Obstruction was nothing. Obstruction was interim order to get this. And consider, Miller, one aspect. I will just beseech to your lordships, Miller. Just beseech to your lordships to consider, Miller. It is maybe in one case I have come to your lordships, Miller. 100 persons. Although they have been selected from 22, 23, because of the few litigants who have come before this court, showing that justice standard orders all should be stopped. Is it the law or is it the Miller? Can be a justice. Justice is a double-way traffic. Justice has those who have come to court, not only they are entitled to get the justice, the persons who have not come to court, they are also entitled to get the justice, my lord. Again, I am saying, Miller, a peculiar course of action, peculiar course of litigations. I don't know which it is whose brainchild, but this has been done in such a way. Entire West Bengal is stopped. Entire West Bengal, no one will get it. Only these persons who are enjoying the dealership, MR dealership, they will enjoy because they have come to the court, they have got an order, got an interim order, therefore nobody's case should be considered. Take a case, Miller, in a case of even an employment. If time, Miller, at one stage, age is also a factor. Time is also a factor. Miller, I argued that point in the upper primary matters. And your lordships have considered. I am so grateful to your lordships. Your lordships have given the wordings there.
That is another matter.
No, I am not. I am another matter. Consideration is what? Consideration is years after years, nobody's appointment can be stopped. That was the consideration. That is the principle of law. I am not talking about other points. Here is also, may not be an employment, but a source of livelihood, sustenance of livelihood.
All right. Yes.
And that will the judgment, if you lost similar that in a case of patently illegal, you give it to.
Yes, tell us, Mr. When you will.
As well, sir. Fixed any date.
My lord, I will just, my lord, 87 and 80.
Very good.
Sorry,
Let him start. Let him start.
No, audience accept.
আচ্ছা appellate side একটা বলো appellate side matter is which one? Appellate side Mr. Bandyopadhyay has finished.
My presence is not required. I think I'm not required.
The appellate side এর ফাইলটা দাও কি অর্ডার হয়ে রয়েছে একটু দেখুন।
4টার সময় ওখানে যেতে হবে আবার।
Yes, Mr.
Now I will start at 4:15. It will finish at 6 o'clock. Then I will run to the airport. Then Delhi, I will go to my Delhi residence at 12:30. I will wake up at 6 o'clock. From 9:30 meeting, 10:30.
But in the appellate side, my lord, 87, 88, my lord, I will make some submission, my lord.
So we are keeping it on 15th.
My lord, there is no records, my lord. We already finished, my lord, that they have already completed their argument.
No, they will start reply. You give your reply. We are not running away. We will listen to it.
My lord, first please.
We have recorded Mr. Bandyopadhyay has concluded. এইটা না এটার সাথে রেখে